वो earphone मतलब नहीं आवाज आ रही है नहीं
वो शेयर करोगे ना स्क्रीन शेयर जब करोगे
छोड़ दिया Yeah, we welcome everybody in the meeting today. And our host is Udita Singh. Udita ji, I hand over the mic to you. Please start the meeting.
Thank you, sir. A very good afternoon to one and all present. I, Advocate Udita Singh, welcome all our esteemed guests, members, and viewers to the 10th Seminar on Insolvency and Bankruptcy Code 2016, organized by All India Insolvency Professional Association in collaboration with GIPA Professional Association, New Delhi, Kerala Insolvency Professional Forums, Kochi, and NCLT Kolkata Bar Association, Kolkata, wherein we shall be discussing various recent judgments pronounced by the Honorable Supreme Court and Honorable NCLAT in the realm of IBC. First and foremost, I invite the Honorable President of AIPPA, Manoj Kumar Anand sir, a chartered accountant and an insolvency professional with vast experience, to start the seminar with a few words of encouragement. Over to you, sir.
Thank you, Udita ji. Mamta ji, namaskar. Kaise hain aap? How are you? Absolutely
fine.
fine.
I'm fine. Thank you so much. Thank you.
You know, I'm really happy to see your scintillating face. After she was. I just shared with everybody. She passed through a very big bypass surgery, and now, yes. Now she is absolutely okay. And in fact, इन्होंने मेरे को motivate करा था कि मनोज जी बहुत time हो गया 2-3 महीने हो गए हमारी meeting नहीं हुई तो please have a meeting only in the last week. हेमंत गोयल सर ये हमारे आज जो क्या कहते हैं हमारे जो चीफ गेस्ट हैं हेमंत जी नमस्कार वेलकम टू द मीटिंग
नमस्कार जी नमस्कार सभी को
ये ना दिस इज आवर 10th आईपा मीटिंग और हेमंत जी हमारे इनकी इंट्रोडक्शन उदिता जी प्लीज हेमंत जी को वेलकम करो और इनको इनवाइट करो क्या कहते हैं अपना इनॉग्रल एड्रेस करने के लिए टू ऑल द ऑडियंस
Thank you. By profession, Hemant sir is a law graduate and a master of business administration. Sir is also the chief executive of International Association of Indian Professionals and also a founding member of Global Jurix LLP, a leading full-service law firm in India. Hemant sir's expertise includes capital market, finance, IPO, GDR, ADR issue, international taxation, foreign direct investment, amongst many others. Being a social visionary with a deep sense of commitment and responsibility to bring about equitable benefits of education in new and innovative techniques, Hemant sir has recently launched 3 universities, namely Himalayan University in Itanagar, Usha Martin University in Ranchi, and Mangalayatan University in Aligarh and Jabalpur. I now hand over the mic to sir to share a few words with all of us.
Thank you very much, Uditi ji. Thank you, Manoj ji. And thank you, AIIPA, Association of Insolvency Professionals, especially to its president, Mr. Manoj Anand ji, जिन्होंने आज के इस प्रोग्राम के अंदर आप सबके साथ इंटरेक्शन करने का मौका दिया और डिस्कशन के अंदर हमको बुलाया. It is my privilege to be with all of you. In fact, I am also in education field, and I collectively, along with my whole team, are running 5 universities. Although I was an advocate by profession, but from last few years, I am more focusing on education sector, and my other colleagues are running our law firm and all the things. So, but this education, profession and business, therein, in fact, doing this for all last 5-6 years, lot of new laws have come up, which include like GST, insolvency, and all other legal development gone in Indian legal system. So I think IBC is an innovative and very young law coming out there in, and I found that there are a lot of interpretational issue in IBC, and the Honorable Court, especially Supreme Court and various High Court, trying to settle these interpretational issues. But the things are coming and again to how to resolve all the things, because the very new concept, and it will take a little bit more time to settle all the things. And we also can see a lot of the best professionals from the industry, from legal side, from company secretary side, from the chartered accountant professional are coming in this profession, who are helping various companies and practicing this law. So this is the first time which is, best professional from the industry to either involve in IBC to take any company or any debt, or how to come up in this practice. So in near future, I am very hopeful that Supreme Court also trying to settle all these issues which come up again and again. In fact, I found a particular law does not only change, but evolving also and revoluting also. So just to understand the mitigation of all these things, I'm really thankful that we have highly experienced and renowned senior advocate, Mr. Madan, also with us. And I wish all the best to All India Insolvency Professional Association and the whole team who is organizing this webinar. Thank you very much. Thank you, Anand.
Thank you, Hemantji. Thank you very much. We are seeing, we have Mr. S.K. Sharma also, Mamta ji also, and other senior faculty members also. Udita ji, please, start your deliberations. We welcome Sharma ji. S.K. Sharma ji, you are welcome.
Now, thank you, sir. Thank you for your words. And I am hopeful that this session will solve a lot of issues, especially the interpretational issues in the IBC, as you mentioned. Now, moving on, I invite Shri Raju, the Honorable President of Kerala Insolvency Professional Forum, to address one and all present. I think
Raju ji, आप unmute कर लीजिए अपने आप को.
I'm sorry. Good afternoon, Hemant ji, our faculty, GP Madan ji, and Mamadam Madam, our President Manoj Kumar, President AIPA President, and Advocate Udita Singh, coordinating this program. We are very proud and happy to associate with AIPA and GPA for this kind of value-added addition programs, which will enhance the the knowledge level of all the members of these organizations. I wish all success, and all our members will be enriched by this kind of programs. I wish all success for this program, as well as for all the future endeavors of these three associations. Thank you so much.
Thank you, sir. I also extend a very warm welcome to Shri S.M. Gupta, the Honorable President of NCLT Kolkata Bar Association, to say a few words. Sir, over to you.
On behalf of Shri S.M. Gupta ji, the president of the NCLAT Kolkata Bar Association, I, the vice president of the said association, welcome all of your good selves. I'm sure this is going to be a very meaningful session, because I think every fortnight now IPA will try and endeavor to see that all the latest happenings in the courts, be it the NCLAT or the Honorable Supreme Court, is brought to your hard step. I can't say doorstep, but hard step, because I think all insolvency professionals have given their heart to this law, and the advocates who are making sure that this law unfolds itself in so many different ways are also here to actually give new meaning to each line that we read differently each moment. So a very happy learning. Let's see what our speakers have in store with us. And of course, pre to that, we will be also very fortunate to hear Mr. Anand, who will be giving us the snapshot of what has happened in the last fortnight or a month. Thank you, Udita.
Thank you, ma'am. Thank you so much. Before moving on ahead with the topic of the discussion, I also want to invite Shri Praveen Jain, the Honorable President of JIPA Professional Association, to share a few words.
So we can move forward, and I welcome Madan sir also. Please move ahead.
So should I give an introduction of Madan sir before going ahead?
Sir, उनकी introduction की कोई जरूरत ही नहीं है, लेकिन फिर भी
yes, there are many viewers who must be waiting, and I think it will be helpful. Being a well-known name in corporate and commercial laws, GP Madan sir is an advocate and an insolvency professional by profession. To add to sir's long list of achievements, Madan sir has also been a significant office bearer and a member in various renowned organizations and associations, namely Indian Institute of Corporate Affairs, ASSOCHAM, ICSI, PhD Chamber of Commerce and Industry. Having been involved in more than 100 cases under the Insolvency and Bankruptcy Code, as a legal counsel and as an advisor to many corporate debtors, creditors, resolution professionals, liquidators, resolution applicants, etc., we are sure that today's session will be an enriching one. Over to you, sir. Now we may start.
Over to me or over to Manoj ji?
So as you wish, you may start, Manoj ji may follow, or we can have an interactive session.
I'm waiting for the snapshot from Manoj ji.
Sure, then we can have snapshot from Anand sir first, and then we can go ahead with your insights on the same.
Manoj ji, please unmute.
Happened was that ki traditionally what happening was that ki always take up a topic कि जो भी पिछले 15-20 दिन एक महीने के अंदर latest case laws हों या कोई latest happenings हों which are concerning with the IPs, तो that has created a lot of interest among all the peoples. लेकिन इस बारी मैंने उसको नहीं लिया बिकॉज वो मेरा सब्सटेंटिव पार्ट होता था ना, वो केस लॉज के ऊपर ही होता था. तो इस बारी सिंस आई हैव रिक्वेस्टेड मदान सर टू टेक अप द लेटेस्ट केस लॉज एंड दैट इज व्हाई आई एम स्किपिंग ऑल दिस थिंग्स. लेकिन फिर भी मैंने इफ एनी केस लॉज व्हिच इन माय ओपिनियन और व्हिच इन माय विजडम बी लेफ्ट ओवर, या एक मैंने छोटी मोटी सी पीपीटी बनाई भी है, तो वह मदान सर के लेने के बाद मैं लूंगा और उस समय फिर मैं उन पर्टिकुलर पॉइंट्स को डिस्कस करूंगा. और एज फार एज अदर थिंग्स आर कंसर्न, ये हमारी आईपा की 10th मीटिंग है. हम लोग जनरली महीने में 2 मीटिंग्स लेते हैं, लेकिन पिछले 1.5-2 महीने में बिकॉज ऑफ सम पर्सनल कंटीजेंसीज वी कुड नॉट टेक अप द मीटिंग्स. और आज हमारी गैदरिंग अप्रोक्सीमेटली 100 लोगों के आसपास होती है, लेकिन आज मेरे ख्याल में वो ईयर एंड होने करके मोस्ट ऑफ द आईपीज आर कंसर्न्ड ऑफ हैविंग देयर completing their quota of 60 hours in a span of 3 years, and most of the IPs are interviewed with those webinars or seminars जहां पे उनको CPRs का क्रेडिट मिलेगा. तो that is there. At the same time, मैं जो भी हमारे प्रेजेंट लिसनर्स हैं, मैं इन सबको एक आईपा की तरफ से ऑफर देना चाहूंगा कि वी आर ऑलवेज लुक आफ्टर न्यू स्पीकर्स, new moderators in that process. उदिता जी को मैंने इस बार इनवाइट करा एंड शी हम्बली एक्सेप्टेड आवर रिक्वेस्ट आल्सो. सिमिलरली अगर आप में से भी कोई बंदा आईपा का प्लेटफॉर्म पे आके अपने आप को डेवलप करना चाहे, जब एज ए स्पीकर और एज ए मॉडरेटर और मे बी इन एनी अदर वे, ही इज मोस्ट वेलकम. So now I, without taking much time, now I request Madan sir to, deliberate on today's topic and enlighten us. मैं आपको बता देता हूँ, मदान सर को आप में से काफी सारे लोगों ने सुना होगा, लेकिन इनका बताने का स्टाइल और इनकी जो प्रैक्टिकल नॉलेज होती है, स्पेशली विद द सुप्रीम कोर्ट केसेस, बिकॉज ही हैड अ लॉट ऑफ सुप्रीम कोर्ट केसेस, जैसे पर्सनल कंटेस्ट के बारे में जब भी मेरे को कोई इंटरनल इंफॉर्मेशन लेनी होती है, इनकी तरफ से मेरे को बड़ी स्टीक सी इंफॉर्मेशन मिलती है, बड़ी टू दी पॉइंट एंड प्रिसाइज इंफॉर्मेशन मिलती है. तो जो चीजें यानी कि जर्नल में या न्यूज़पेपर में या मीडिया में नहीं आती, उस तरह की इंफॉर्मेशन भी सर के पास होती है रिलेटेड टू केस लॉस, यानी कि हाउ द पर्टिकुलर केस इज डेवलपिंग एंड हाउ एवरीथिंग्स आर मूविंग. तो वी आर रियली, हम इनको बहुत फ्रीक्वेंटली बुलाते हैं. तो और सर को जब भी रिक्वेस्ट करते हैं तो अपना टाइम निकाल के ये हमारे को अपना टाइम जरूर देते हैं. वी आर रियली थैंकफुल फॉर दैट. तो वेलकम मदान जी. नाउ प्लीज टेक द माइक एंड स्टार्ट योर डेलिब्रेशन.
ऐसे इंसान को बोलते हैं इनसाइडर, या हिंदी में बोलते हैं खबरिया. थैंक यू एवर स्माइलिंग मनोज जी and ever charming, always refreshing Mamta ji, Udita, Hemant ji, SK Sharma ji, all other dear friends. Welcome to this webinar where we are going to discuss some of the recent landmark judgments or orders pronounced by Honorable Supreme Court of India or Honorable National Company Law Appellate Authority. Udita, in her opening remarks, said that a lot of issues are going to be sorted out. I don't know whether we are going to sort out the issues or whether we are going to discuss the more confusions. Because some of the judgments, there are more confusions than the clarifications which have been given by the judicial forums. I'm not criticizing
Confusions
that.
often lead to enlightenments, and they often lead to very good solutions. So I hope that those
It's not
confusions.
necessary. Had the solutions been there, IBBI would not have approached Supreme Court and filed an impediment application. That before you pass any further judgment in the review petition in case of rainbow papers, please hear us also. Because it is being said that rainbow judgment is against the spirit of the code. I don't know whether I should touch upon rainbow today or not. If the time permits, we'll discuss about rainbow, because otherwise rainbow we have already had many webinars. So I have actually, it was very difficult task to pick up which judgments or orders I should take up. But still I have tried that in next 40-45 minutes, maybe an hour's time, the judgments or orders which we can discuss. And I would like you also, all of you, to please share your views or your experiences, because the cases which are going to discuss today, I'm sure majority of you must have faced the same situation or must have undergone the same facts in your cases. So what was your view, or how did you handle that particular situation? I would like to have your views also, because I would want to have this sort of two-way communication, not one-way communication from my side only. Because I am seeing number of insolvency professionals who are handling number of cases as IRP, RP or liquidator, or maybe representing their clients. Manoj ji, you said that number of participants who are participating in this webinar is less. I will say it is more than my expectation today. Because somehow or the other, मुझे ये लग रहा है कि धीरे धीरे इंसॉल्वेंसी प्रोफेशनल्स जो हैं वो indifferent होते जा रहे हैं. And there are reasons for that. Number one reason, no doubt, the number of applications which are being filed is going down. Maybe because of the 1 lakh to 1 CR. Or maybe because of, in case of real estate, 10% or 100 allottees stipulation. Maybe because of rainbow. Maybe because of the delays in before the adjudicating authority, the banks and the financial institutions have decided to go for some alternate remedy rather than going for IBC. And last but not the least reason, according to me, the way the strictures are being passed, the way the orders are being passed by the regulator and also by the judicial forums against the insolvency professionals. That is also acting as one of the deterrent. The number of insolvency, because I deal with so many insolvency professionals, I have discussions with them. Number of IPs have started thinking whether we should continue with this profession or not. Though that's not the topic of the day, if we start deliberation on this, I think the next 2 hours will be devoted to this topic only. And we're coming to some of the prominent judicial pronouncements. Majority of them which I'm going to discuss are from the Supreme Court, and a couple of them may be from National Appellate Tribunal. Do I have sharing rights with me? No. Manoj ji,
You are a co-host, you have a sharing right, sir.
अभी नहीं है सर, दे देंगे तो अच्छा रहेगा.
चलिए हम आपको होस्ट बना देते हैं.
ममता जी होस्ट हो गई हैं, मैं अभी भी नहीं हुआ हूं.
अब सर स्टार्ट करिए, मैं करता हूँ.
स्टार्ट कर नहीं सकता ना, मैं पीपीटी कोई ओपन करनी है ना मैंने. It is still showing host disabled participant screen sharing.
What I'm doing is I'm making him the co-host, Manoj ji, then he will be able to do it.
Actually, make it, yeah, please do.
हाँ, हाँ, एक बार आप देखिए मदान जी, आप कर पाएंगे.
Absolutely, thank you.
हाँ, welcome.
Just a minute. Is it visible?
Absolutely.
Thank you. मनोज जी की रिक्वेस्ट आई थी कि पीपीटी अगर हो जाए तो आज मैंने बैठ के पीपीटी बनाई थोड़ी सी. First of the judgment which I'm going to share is from the Supreme Court, and the order has been delivered on 26th of August 2022. What has happened in this case, that a company imported certain goods way back in 2017, and after that the company went into CIRP. But as the duties were not paid, So the custom department, the goods were lying in the warehousing facilities of the custom department. When the company went into CIRP and ultimately the liquidator was went into liquidation, a liquidator was appointed. The liquidator filed an application before the NCLT seeking a direction against CBDT to release the warehouse goods. And NCLT allowed the application and directed CBDT that please you release the goods which are there in your custom warehouse. Now, against his order of NCLT, Custom Department filed a preferred an appeal. Now, NCLAT admitted the appeal and directed that the warehouse goods can be released or disposed of as per applicable provisions of Custom Act by the proper officer. It means NCLAT decided that unless the duties are paid, the goods cannot be released. Now, against this order of NCLAT, now liquidator approached the Supreme Court. So friends, first of all, we need to take a call that being an IRP, RP or liquidator, at what stage we can also prefer an appeal. Sometimes we do not prefer an appeal because of the reason that who is going to support us, what shall be the finances which will be available at our disposal, what sort of legal facilities or legal assistance will be available, who is going to pay the fee, can we engage a senior? Because if you're going to Supreme Court and other parties are going to engage a senior, against a senior, you have to have a senior. Now, who shall pay the fee? Now, the company is under liquidation. In this case, company is under liquidation. To take a call on the appointment of a senior counsel, and all of you know what is the normal fee of a senior counsel per appearance. Before Supreme Court, it may range from 1.5 lakhs to 15 lakhs. This is the broad range I've discussed with you. तो आप किस तरह का सीनियर काउंसिल करेंगे, उसकी फीस कौन देगा, डिसीजन कौन लेगा, और कल को आपने डिसीजन ले लिया and after that when an inspection is conducted by IBBI, the IBBI may raise certain questions. Who authorized you to engage a senior?
Madan sir, one second. It should be CBIC, not the CBDT.
Maybe. I think the facts where from I've taken the fact it was CBDT mentioned there. Because some of the portion I've taken copied from there, though it should have been CBIC. I am absolutely with you, Mr. Joy. It should have been, because otherwise it's Center for Direct Taxes, it should not have been direct taxes.
In the abbreviation, you have
okay. I think that in the brackets it's wrongly written CBDT, otherwise CBIC only. That is why I have not shared this PPT so far with anybody.
Okay.
Thanks for correction.
Welcome, sir.
So I was on this issue that even being a Joy sir, koi nahi, aap apne aap, you can put your video on mode. I want to see certain good faces. So now liquidator needs to take a call whether an appeal should be preferred or not. But for all practical purposes, my humble submission is at such point of time, it's always advisable to convene a SCC meeting, put your proposal before SCC and take all these SCC members into confidence and should be a concurrence. Yes, an appeal should be preferred, and what can be the estimated expenses, estimated cost of filing or contesting this particular appeal. So this is off the record, but actually this problem we normally face while conducting a resolution process or a liquidation process. So now against this order of NCLAT, which literally said that goods can't be released, to be very frank, an appeal was preferred by the liquidator. Now the issues before Supreme Court are whether the provisions of IBC they supersede those of Customs Act, and if so, to what extent. All of us know Section 238 non-obstante provision is there. that notwithstanding anything contained in any other law for the time being in force, in case of any inconsistency, the provisions of IBC shall prevail. But we have seen number of judgments or number of judicial pronouncement where it has been said, no, here 238 will not be applicable. Even Rainbow is such a case. Here 230 has not been made applicable. The another question before the Supreme Court was, can the custom authority claim title over the goods of the CD against whom liquidation order has been passed? So these two issues were there before Supreme Court. What Supreme Court has decided now? Supreme Court has decided that in terms of IBC and Custom Act, if there is a conflict, in case of such conflict or in case of such inconsistency, the provisions of IBC shall prevail over Customs Act, because we have section 238. And even in case of there is a question of moratorium under section 14 or under section 33 subsection 5 of the code, again, the provisions of code will prevail over the Customs Act. So therefore, they decided that custom authority is having limited competence to assess or determine the quantity of customs duty and other charges. Furthermore, the customs authority cannot initiate recovery of dues through sale of this confiscated goods. So it means practically Supreme Court decided that these goods for all means have to be released, and so custom authorities cannot recover its dues by selling the goods which are lying in its confiscation, in its godown, in its warehouse. Simply because the duty has not been paid earlier. Now, with regard to the claim of the custom authority over the goods of the CD, it has been decided that no claim under the Custom Act can be brought over the commodities once the liquidation has begun. Because issuance of the notice under section 72 of the Custom Act for non-payment of custom duty falls squarely within the ambit of initiating legal proceedings against a CD, which is barred under section 14 of the code or under section 33(5) of the code. So once a moratorium is there, no legal proceedings can be initiated, including by the custom department for recovery of its goods, recovery of its duties, that is the custom duty, or for selling the goods which are lying there in the warehouse. These proceedings cannot be initiated. Whatever goods are lying with the custom department, those they belong to the corporate debtor and shall become part of the liquidation estate. I would like to, if somebody is having any experience on a similar, in a similar situation, please share your experience also.
If I may, the issue is the case which I was handling, Lanko Babat. Similar issue was involved there where the learned NCLT, and it was prior to the judgment came, where the learned NCLT said that, look, the goods which are lying in the warehouses, they are not your property. They are not your goods until
your means CDs or departments?
CDs. This is
okay.
what the NCLT said, that under the Custom Act, until and unless you clear the dues, the custom dues, you do not have any ownership of those goods. So when they are not your goods, how can they form part of the liquidation estate? And while the appeal was pending before the NCLAT, I think the judgment in this matter came by the Honorable NCLAT, and then it finally came from the Supreme Court. But the issue was this. So it was surprising that Supreme Court has taken, and it was surprisingly good that the Supreme Court has taken a different view on this. So I think you can also speak a few words on that too, that whether those goods which are lying in the custom and the duties have not been paid, are they the assets of the corporate debtor or not?
What we being lawyers or being professionals, what we need is a clarity. If there is confusion on a particular issue, we need clarity. Now NCLT says no, they do not belong to CD. NCLAT says no, sorry, NCLT says they belong to CD in this case. NCLAT said no, they do not belong to CD, they belong to Custom Department. Now in these two situations, what we need is a clarity from the Apex Court. Now Apex also provided the clarity. So let's not try to interpret it whether the Apex Court had decided it rightly or wrongly. We as insolvency professionals also, we also need some clarity. Now the clarity has been provided and the clarity shall prevail in other cases, and we need to apply this ratio of this judgment in other cases to the extent it's possible.
Sir, one more opinion. In case if the liquidator want to dispose these goods, then he will be required to pay the applicable customs duty. Then only he will be able to do that, is it not?
I don't think that issue has been decided here. According to me, for the purpose of this duty, according to the customs authority should file their claim before the liquidator. And once they are filing the claim, then the claim shall be dealt with as per section 53 of the code. So if in all fairness, the goods have to be released without payment of duty, and the goods will become part of the liquidation estate. Otherwise, if we say that first of all, the duty has to be paid, where from the duty amount will come, how these goods will be sold, there may be a possibility tomorrow that whatever duty you pay and the amount which is to be realized out of these goods, that amount is much lesser than the duty which has been paid by the liquidator, because you never know what is the status of these goods.
Correct.
They may be some perishable items, you never know. It might have become junk.
Because in case of any sale under liquidation or CRP, the applicable tax laws must be complied during CRP by the liquidator.
That is, those taxes are on sale.
But this once the goods are in.
But that is a transaction which is happening during liquidation period.
Yes, sir.
So those taxes and duties of those transactions. Here the transaction is already taken place in 2017. Yeah. It's an old transaction before commencement of CIRP even.
Yes, yeah, once the goods are parked in a bonded warehouse and releasing amounts to import to the country. So when the liquidator releasing the goods, then he will be most probably he will be liable to pay the applicable tax. Tax
if that is a scenario, then so certainly on all outstanding loans, the interest should also be has to be paid, because that money belongs to the public. Which is money which is there in the banks, and banks have lent that money. Even the interest on that has to be paid. So that's a never-ending process. Again, we are coming to the square one situation before CIRP, before IBC. But certainly, if some goods have been imported during CIRP or during liquidation, if something has been imported during that period, the duty has to be paid on that. But something imported earlier, lying in the warehouse, no duty is required to be paid. This is my take.
Thank you so much.
Anybody else would like to say anything on this? Okay. The next judgment which I've taken is Kotak Mahindra Bank versus Key Precision Parts. That is decided by Supreme Court on 5th of August 2022. If I come to the issues, actually that is with respect to limitation. And it's a very interesting case study, I tell you. Here's what has happened. The CD availed certain facilities from Kotak Mahindra Bank. And CD defaulted in repaying the dues. And on 30th of September 2015, the dates are important because from the limitation point of view, the dates are always important. On 30th September 2015, the account was classified as NPA by Kotak Mahindra Bank. Now later on, an OTS proposal is submitted by the corporate debtor, accepted by Kotak Mahindra Bank, and a settlement deed is signed on 20th of December 2018. Now you see there is a gap of 36 plus 4, 40 months, 3 years, 4 months. The amount was declared as classified as NPA on 30th September 2015. Settlement is signed on 20th of December 2018. But CD fails to adhere to this settlement deed. And very next month, that is January 19, Kotak Mahindra Bank files an application under Section 7 of the code. Now, what the CD says? CD says this application is time barred. Because the application has been preferred after 3 years. The company's account was classified as NPA in September 15. Now the application is being filed in January 19. So this is after 3 years, application is time barred. And even the settlement proposal, if any, was there in December 19. That was also after 3 years. However, now this application is admitted. NCLT says, sorry, nothing doing, no limitation is applicable here. And application was under section 7 was admitted. Now, against this order, an appeal is preferred by the directors of the corporate debtor. And NCLAT reverses the order of NCLT. It means NCLAT holds that yes, limitation period is applicable. Here in this case, the application under section 7 has been preferred after a period of 3 years. If you read the last sentence on this, in the last para, it says the NCLAT also observed that to extend the period of limitation, an acknowledgement must be with respect to the subsisting debt, that is, acknowledgement must be given prior to the expiry of the limitation period. Because the other Kotak Mahindra Bank says that in December 18, there is an acknowledgement. December 18, when the settlement deed is signed, there is an acknowledgement on the part of the corporate debtor. Yes, I owe you a debt. So a fresh limitation period should start from this date. But NCLAT says, no, sorry. Even this acknowledgement should have been there within a period of 3 years. Here in this case, no doubt there is an acknowledgement, but acknowledgement is after a period of 3 years. So the issue before Supreme Court, can CIRP procedures be concluded without evaluating the question of applicability of Section 5 of the Limitation Act, that is with respect to condonation of delay? Supreme Court has decided in this case that even though the debt was barred by limitation, same cannot be revived by OTS, dated 12th of December 2018. I think it should be 20th. One of the dates are wrong. The terms of the said settlement signed by FC and CD constituted an agreement to pay a time bar debt. So December 18, this settlement is talking about payment of a time bar debt, which is enforceable under section 25(3) of the Indian Contract Act. So Supreme Court ultimately holds that in terms of section 25(3) of the Contract Act, because there is a new contract, the terms of settlement between the parties were enforceable within 3 years from the due date of payment thereunder. Since the due date under the terms of settlement was December 31st, 2018, the application which was filed in January 19 was held to be within the limitation period of 3 years. So what Supreme Court has said, that by virtue of this settlement in December 18, a fresh contract has been entered into between the parties. So by virtue of this fresh contract, the fresh limitation period of 3 years shall start from December 18 and not from September 15. So therefore, then admission of the application under section 7 of the code by Honorable Adjudicating Authority was upheld. Another case, ARC versus Tulip Star Hotels. Here what has happened? The CD's account is declared NPA. On which date? On 1st December 2008. After which the CD admitted this liability and requested for a settlement in February 2011. Actually, in this case, this settlement proposal is also moved within 3 years. Because December 1, NPA, February 2011, December 2008, NPA, February 2011, settlement proposal. And ultimately what happens, along with this, the liability of this debt is acknowledged by the CD in its financial statements from 2008-9 onwards till 2016-17. तो 31 मार्च 2017 की जो बैलेंस शीट बनी, बैलेंस शीट नो डाउट बाद में 6 महीने के अंदर बनी होगी, उसमें भी ये लायबिलिटी कंपनी की तरफ से आ रही है that the company owes this debt to asset reconstruction company. Now, April 2018, application under section 7 is filed. And now it is argued there that is barred by limitation because the company's account became NPA in 2008 And now the application is being filed in April 2018 after a gap of 10 years. So what is the issue before the court, Supreme Court now? Will there be a new limitation period if the CD acknowledges the debt before the limitation period expires? Here in this case, if you see, the limitation period was expiring on 1st December 2011. But before that, there is a settlement proposal. Before that, there is a liability in the books of the corporate debtor. There is acknowledgement of the liability. मनोज जी, कुछ लोग तो अपने फेसेस दिखा दो, ऐसे ऐसे लगे मैं अपने से बात कर रहा हूँ स्क्रीन पे. So now how this issue is dealt with by Supreme Court? Supreme Court has decided in this case that an application under Section 7 would not be barred by limitation on the ground simply that it had been filed beyond a period of 3 years from the date of declaration of loan account as NPA. Because if there was an acknowledgement of the debt by the CD before the expiry of the period of limitation, and in that case, the period of limitation would get extended by a further period of 3 years. And here in this case, the company's books of accounts, the financial statement reflected this liability till 2017, March 2017. So if after that the company is not showing its liability in the books of accounts, but a 3-year period shall start from 1st of April 2017. And here the application has been preferred in April 18 only. Therefore, Supreme Court observed that entries in the books of accounts of a company can be treated as acknowledgement of liability in respect of debt payable to financial creditor. And therefore, till that time, this acknowledgement of liability is there in the books of accounts of the company, in the financial statement of the company, the limitation period shall start from the last appearance in the books of accounts. And in this case, till last date, the debt was being reflected in the books of accounts of the corporate debt.
Madan sir.
Yes.
One point in the last year, the Vishal Jaiswal case, no, Nariman said, no, from the balance sheet entries, the new limitation period, it will start. If that be the case, no, since every year the balance sheet it is there, from every year, it will get extended.
Yes. Yes. Exactly, that is what the court is saying.
Then almost these 3 years, it becomes irrelevant. In every case, where it is.
No, suppose after 2017, the company stopped showing in the financial statement. And then an application is preferred in year 2021. So in that scenario, the limitation period has already expired. It has come to an end. Suppose after 31st March 2017, the company does not reflect this liability in its financial statement.
Okay.
And now the financial institution prefers an application in, say, April 2021. So that will be barred by limitation.
So this Vishal Jaiswal case, it has got a retrospective applicability.
Sorry, I couldn't get you.
See this Nariman judgment, no, it has got a retrospective applicability that came in April 2021 only. So
no, that's okay. But we have to see the dates, by which date the amount was reflected in the financial statement and when the application was filed. Those 2 dates are important.
Okay.
Yeah.
Sir, इसमें एक मेरा छोटा सा क्वेश्चन है, as a matter of planning, because CA का दिमाग हर जगह ज्यादा चलता है. Let's presume a situation that 3 years have passed after NPA, and company, instead of showing it as a liability in the balance sheet, they show it as a contingent liability in the notes to accounts, or maybe given a footnote to that thing instead of showing it as a liability on the face of the balance sheet. In that case, since you're expert in company law also, what's your opinion? What's your call?
It's a double-edged sword. What you are saying, we will not reflect it in the balance sheet, but will reflect in the notes and accounts. In notes and account, you will show it as contingent liability. But certainly you will have to give the reasons also on what basis you have stopped showing in the balance sheet. The auditor is also right. The auditor may also qualify this. It's better you pass a board resolution and do not reflect in the notes and accounts. And let auditor say the board of the management of the company has decided such and such, that's all. The moment you show it as contingent liability also, my view is that limitation period will continue. It will never come to an end.
Because notes of accounts is part of the main accounts.
Yes, part of the main accounts. The somehow or the other, you are acknowledging the liability, that this liability may accrue.
But this may also be counterproductive because usually the balance sheets of NP accounts and all corporate debtors, they're shared with the banks. So the bank will get alarmed by this and they may see foul in this and initiate all sorts of proceedings, even when there might be a chance that the bank is not, trying to initiate CIRP against that particular debtor. So it might also be counterproductive that where the bank is not contemplating initiating CIRP, but seeing that you are trying to bypass the law, they might even take other steps, because 3 years, you'll have to wait for 3 years to ensure that it becomes a time bar debt. And the banks, I think they are vigilant enough to not let that slip.
उदिता जी, जब लड़ाई हो जाती है ना, जब अकाउंट एनपी हो जाता है बिकॉज ऑफ एनी रीजन, फिर वो जो एक हेल्थी रिलेशन होते हैं ना सीडी और बैंकर्स के, वो उनको बैंक स्टेटमेंट्स देना, स्टॉक स्टेटमेंट देना, सब कुछ बंद हो जाता है. In any case, thank you very much. We understood your law also. What you want to say? We understood your law also.
पर्पस के लिए एक सेपरेट स्टॉक स्टेटमेंट बनती है, एक सेपरेट फाइनेंशियल स्टेटमेंट बनती है, which is not available in the records of the ministry.
सर वैसे भी बैंक जाने वाले नहीं है, क्योंकि बैंक का एनसीएलटी नहीं जाने वाले हैं. बैंक का एक्सपीरियंस बहुत अच्छा नहीं है. और आज की डेट में तो मोर पर्टिकुलरली दिल्ली में तो, क्योंकि कोई मीटिंग हुई है, आईबीसीआईपी के चेयरमैन ने मीटिंग कॉल की थी और वहां पे 4-5 बैंकों ने कंप्लेंट की है, तो सारे जजेस जो है गुस्सा हुए बैठे हैं कि भाई आप हमारी कंप्लेंट करते हो, हम आपकी पिटीशन डिसमिस करेंगे. तो कोई बैंक पिटीशन नहीं फाइल कर रहा है. आप बताइए, पंजाब नेशनल बैंक ने दिल्ली में 2022 में कोई एक सिंगल पिटीशन फाइल नहीं की है दिल्ली रीजन में, क्योंकि कोई रिकवरी होती नहीं है. 2-3 साल पड़े रहते हैं, 2-2 साल जो है प्लान पड़े रहते हैं. तो कोई बैंक वैसे नहीं जाने वाला, बैलेंस शीट पे दिखाए ना दिखाए. नेशनलाइज बैंक तो कम से कम नहीं जा रहे हैं.
तो अब मनोज जी, शर्मा जी ने रीजन बता दिया कि व्हाई नंबर ऑफ पार्टिसिपेंट्स 50 टुडे एंड नॉट 100.
सर एक्चुअली
मैंने कम से कम लगभग बैंक के बिहाफ पर, पंजाब नेशनल बैंक के बिहाफ पर इनिशियली 30-40 पिटीशंस फाइल की थी बड़े अकाउंट्स में. अब कुछ होता ही नहीं है. एक साल आप पहले ही, जो जज साहब का व्यू क्या होता है कि कितना हेयर कट दिया है, वो प्लान को ऐसे ट्रीट करते हैं कि सब दुनिया चोर है और सबने लूटपाट मचा ली है इसमें. अब देख लो, सबका एक्सपीरियंस जो हर रोज रहते हैं. तो बैंक क्यों जाएंगे वहां, किस लिए जाएंगे, खर्चा करेंगे.
शर्मा जी, मैं इसमें आपको थोड़ा सा
मेरा कहने का मतलब खाली इतना है कि आप बैलेंस शीट में दिखाओ, बैंक जब भी नहीं जाने वाले, बैंक कोई पिटीशन नहीं फाइल कर रहा है इंस्पेक्शन से.
Sir, main thing is that is it applicable for OC as well? If their balance is shown in books of account, then this will be treated as acknowledgement of liability.
Absolutely yes, Babita ji.
Definitely. सर मैं उसमें ये कहना चाहूंगा, लेट्स बी ऑप्टिमिस्टिक. बैंक्स वाले चलिए क्रिप नहीं स्टार्ट कर रहे व्हाटएवर, लेकिन पर्सनल गंटर्स के अगेंस्ट बैंक वाले, एनबीएफसी वाले काफी यानी कि एक्सेस रेशो में जा रहे हैं जब से ये ललित कुमार जैन जी के केस के बाद से क्लैरिफाई हुआ है.
मनोज जी, माय अपॉलॉजीज. पर्सनल गारंटर के अगेंस्ट केसेस वही जाएंगे जिनकी सीआईआरपी एनसीएलटी में पेंडिंग है. अगर सीआईआरपी इनिशिएट नहीं होगी एनसीएलटी में, तो पर्सनल गारंटी भी नहीं आएगी एनसीएलटी में.
सर लॉ डजंट प्रोहिबिट इन दैट वे कि अब सीआईआरपी इनिशिएट करना मस्ट है.
नो, इन दोस केसेस यू विल गो टू डीआरटी.
No sir, in these cases yeah, the banks directly go to NCLT.
Sir, NCLAT की एक judgment है, I'm not remembering the name.
Name I do not, I unable to recall. There is one judgment that without CIRP you can initiate PG.
It has been.
In my opinion also, that judgment is flawed if we read the rules, etc. But the law which is laid down by the Honorable NCLAT and also upheld by the Honorable Supreme Court says that even in case of personal guarantors to corporate data where CRP is not initiated, you can go to NCLT. Though that's obviously a flawed.
I absolutely agree.
But I'm pretty sure even this now the matters, the PG's matters which are pending before Supreme Court, this issue shall also be dealt with at that point of time. And I'm pretty sure this will be in the review, this will be reversed.
You mean to say Gurmeet Sodhi's case?
Pardon?
Gurmeet Sodhi के केस की बात कर रहे हैं आप?
Yes.
सुप्रीम कोर्ट में जो गुरमीत सोधी का केस पड़ेगा उसकी बात कर रहे हैं?
Yes.
सर वो जब रिवर्स होगा तब होगा, लेकिन आज की डेट में लॉ यही है.
मान लिया मैंने आज के ठीक है नहीं, but we should not be complacent कि this is the law of the land. I'm pretty sure this will be reversed.
Okay.
Secondly, अभी आपने कहा कि ठीक है that we shouldn't get discouraged. The number of PG to CD cases are there. Do you tell me how much remunerative is this for the insolvency professionals? These PG to CD cases.
सर हम ऐसा करते हैं, ये हम आईपीएस के ऊपर ज्यादा कंसंट्रेट कर रहे हैं. लेट्स कंसंट्रेट ऑन द केसेस. कोई बात नहीं सर, लेट्स कंसंट्रेट ऑन द केसेस. तो बट एनलाइटनिंग अस दिस थिंग कि ये सुप्रीम कोर्ट माइट रिवर्स दिस थिंग. वी आर रियली एनलाइटेंड बाय योर दिस सेइंग. लेट्स मूव टू द केसेस नाउ प्लीज.
ओके, कमिंग टू नाउ विदर्भा इंडस्ट्रीज वर्सेस एक्सिस बैंक. विदर्भा में बड़ा क्लियरली सुप्रीम कोर्ट हैज, I'll not say rewritten the law, but Supreme Court has clarified the law. And here I am in minority who are supporting this judgment. I'm supporting this judgment of Vidarbha. Because if we read the law, section 7 subsection 5 and section 9 subsection 5, the provisions are pretty clear. Under section 9 subsection 5, there is no discretion with the adjudicating authority. If a debt is there, a default is there, and no dispute is there, the adjudicating authority shall admit the application under section 9. But when it comes to section 7, two things are required to be there. Number one, there is a debt. Number two, there has to be a default. But despite these two things present, still adjudicating authority has a discretion whether to admit the application under section 7 or not. Because deliberately these two were the word may and word shall has been used in section 7.5 and 9.5 respectively. 7.5 uses the word may, adjudicating authority may, while 9.5 uses the term adjudicating authority shall. Had one of these sections been there, तो मैं ये कह सकता था there are a number of Supreme Court judgment may can be read as shall or shall can be read as may. But when in two different sections these two different terms are appearing, then I do not think there is any scope for interpreting may as shall or shall as may. So what Supreme Court had decided in Vidarbha, that once an application is preferred under section 7, and there is every possibility that there is a default on the part of the company which is beyond its control, and otherwise the company is a solvent company. So in such a scenario, the adjudicating authority may not admit the application under section 7. And those who have gone through the facts of the case know it very well that there was a demand from there was a recovery to the corporate debtor. That recovery could not be crystallized by that time. Otherwise, the total amount of default was much less than the recovery. कंपनी ने यही बोला ये अमाउंट मेरा रिकवर हो जाता है मैं इनको पे कर दूंगा. अगर रिकवरी नहीं आ रही है तो मुझे डिफॉल्ट करना पड़ा, मेरी भी मजबूरी है. सुप्रीम कोर्ट ने उनकी बातें सुनी, उनकी बातें मानी. This company is a solvent company. The default was because of particular circumstances. So therefore, the company is a solvent company, and the adjudicating authority very right in not admitting the application. And you know, after this, what has happened? A review petition was filed. This judgment was delivered on 12th of July 2022. After this, a recovery or review petition was filed before Supreme Court. And this judgment was given by Honorable Justice Indra Banerjee. And she demitted her office on 23rd of September. But a day before of her demitting the office, that is 22nd of September 2022, she pronounced her order on this review petition also. And I would like to read 2-3 paragraphs from there. First of all, the learned Solicitor General of India submitted that certain observations made by the Supreme Court in this Vidarbha judgment could be interpreted in a manner that might be contrary to the aims and objects of the IBC and render the law infructuous. क्योंकि अभी तक हम क्या पढ़ते आए थे, एक्चुअली मैं सच बताऊं तो हम सबने भी कभी ध्यान नहीं दिया, हम सबने यही ध्यान दिया डेट है, डिफॉल्ट है, एप्लीकेशन एडमिट होगी। सेक्शन 7 ऐसे ही पढ़ा हमने शुरू से ही, 1 दिसंबर 2016 से, जब तक विदर्भा नहीं आया। अब ये विदर्भा आ गया तो सबने कहना शुरू कर दिया सुप्रीम कोर्ट हैज रीरिटन द लॉ। अभी तक तो डेट और डिफॉल्ट चाहिए था। ये सॉल्वेंसी कहां से आ गई? अगर कंपनी सॉल्वेंट है तो इवन दो देयर इज अ डिफॉल्ट बट कंपनी सॉल्वेंट तो एप्लीकेशन एडमिट नहीं हो सकती है। तो दिस इज व्हाट एसजी आल्सो सेड, सॉलिसिटर जनरल आल्सो सेड बिफोर द सुप्रीम कोर्ट, that the way this law has been interpreted, it might be contrary to the aims and objects of the IBC and render the law infructuous. Supreme Court says this apprehension appears to be misconceived. It has further said, the elucidation in paragraph 90 of this judgment, which is there on your screen, and other paragraphs were made in the context of the case at hand. It is well settled law that judgments and observations in judgments, what does it say? बड़ा ध्यान से पढ़ने वाला है. That judgments and observations in judgments, both, are not to be read as provisions of statute. Judicial utterances or pronouncements are in the setting of the facts of a particular case. To interpret words and provisions of a statute, it may become necessary for the judges to embark upon lengthy discussions. The words of judges interpreting statutes are not to be interpreted as statutes. जब ये रिव्यू पिटीशन का ऑर्डर आया ना, आई वाज सो हैप्पी, और मुझे तो लगा था आई कैन अप्लाई द रेशियो ऑफ दिस ऑर्डर, दिस रिव्यू पिटीशन ऑर्डर इन रेनबो पेपर्स केस, कि रेनबो में जो कुछ डिसाइड हुआ है दैट इज ऑन द बेसिस ऑफ द फैक्ट्स ऑफ दैट केस. Supreme Court has not interpreted the provisions of the statute, or whatever has been said in Rainbow is not statute. मतलब मुझे तो समय तो सोच के बैठा हूँ कि कभी भी जब मुझे रेनबो मुझे अटकेगा ना NCLT में, मैं विदर्भा का रिव्यू पिटीशन का ऑर्डर लेकर, that rainbow is not applicable in my case. Rainbow is applicable in rainbow only, not in my case. और सबको लीड दे रहा हूँ मैं आप सबको. You can always quote this order of review petition.
Right, Mr. Mata. Anyway, the rainbow judgment is not applicable to all the statutory dues. It is because of the schedule, whatever laws is not.
Yes. So only Gujarat VAT.
Yes, Gujarat VAT and few other.
No. If you read Rainbow, the Rainbow talks about statutory dues of any authority, any legal authority. Unless those dues are paid, the no resolution plan can be passed by the adjudicating authority. These are the
But
wordings.
when you read deeply into it, you understand that this has come because, and anyways, that time the law had not got amended. So anyways, this does not hold good.
Oh, okay, you are talking about the proof claim or proof of claim.
Correct.
You are on that.
Also,
but if you leave that aside and come to the later paragraphs of this judgment, which have got nothing to do with the claim, they are talking about the dues of the legal authority and other authorities. And actually, I tell you, in Delhi, what has happened? In number of cases, number of government authorities now have started filing impediment application that this plan should not be approved. Our dues have not been paid. Rainbow is applicable to us.
Yeah, but Mr. Madan,
सर इसमें एक बात मैं ममता जी प्लीज आप
नहीं आप बोलिए आनंद जी, it's okay.
नहीं प्लीज अपनी बात खत्म करिए ममता जी.
I was only saying that in the schedule, because of the non-obstante provisions, when the schedule is overtaking, where the laws have actually very honestly said that now this is going to overpower, the IBC is going to overpower, those government dues is very clear. On that, Rainbow is not applicable. Only where the changes has not occurred, where the Rainbow is becoming applicable.
Again, this is a matter, I'll say this is a matter of argument. You know, in here,
that's what we are working on.
Noida and Greater Noida Authority have started filing number of applications in number of pending cases.
They could have.
सर मैं इसमें एक बात और ऐड करना चाहूंगा. रेनबो के अंदर जो गुजरात वैट की जो जजमेंट थी, in that particular case, they attach the properties also. By virtue of attaching those properties, they become secured creditors. That was also one of the vital issue. Number one. Number two, in fact, it is happening with me also that wherever taxation dues were there, now they start crying in every COC meeting also, take care of us, otherwise we shall go this thing there. Noida and Greater Noida Authority, what the example and other tax authorities example which you are giving. In fact, it is, I would like to have the opinion of my other learned IPs also, that most of the NCLT is not passing their registration plan, only keeping in abeyance to have the proper interpretation of this rainbow in whether that has been made part of registration plan or not. In fact, what is happening in Delhi, they are not passing. What is happening in other states?
Tell you, because no NCLT benches are also waiting for the outcome of the review petitions in rainbow.
Yes sir, yes sir.
मदन साहब, मुझे भी 2 मिनट का टाइम देना. मैं अपना एक एक्सपीरियंस शेयर करूंगा एनसीएलटी प्रिंसिपल बेंच का.
करिए ना प्लीज.
इससे मिलता जुलता ही ईपीएफ अभी करूं या बाद में करूं?
नहीं, पर्टेनिंग टू रेनबो है तो अभी कर लीजिए, नहीं तो फिर बाद में रेनबो निकल जाएगा.
पर्टेनिंग टू आप रेनबो कर लीजिए, मैं सबसे बाद में करूंगा. मुझे टाइम देना 2 मिनट.
नहीं, whether your
it's similar to the rainbow. It's about the EPFO dues.
ओके, ईपीएफ ड्यूज जो प्रायोरिटी है लिक्विडेशन कॉस्ट से भी पहले. चलिए शर्मा जी, हम उसको भी लेंगे.
मेरे ख्याल से ईपीएफ ड्यूज आर आल्सो, नंबर ऑफ आईपीज आर फेसिंग दिस इशू ऑफ ईपीएफ और ग्रेच्युटी ईएसआई आल्सो. शर्मा जी प्लीज.
माय एक्सपीरियंस, एक कंपनी थी ग्रिड हाइथ्रो पावर लिमिटेड. इट वाज वेंट इनटू द CIRP in the year 2018. My client has submitted one plan. This was approved by 100%. I am audible?
Yes, absolutely. Please carry on, Sharma ji, please.
My client submitted the plan, which was approved by the 100% voting by the financial creditors. EPFO has filed its claim of rupees 161 crore, which was as a operational creditor. That RP accepted his claim and make a provision of the payment of his dues of, I think there was a provision of 3% for the operational creditor. Plan was approved. We filed the application for approval of plan. At that time, what is they are saying, interesting thing in this matter is that EPFO claim is based on the ex parte assessments. And at the time of argument, they have admitted that they don't have the list of the even employees, list of employees. When the bench asked them to question how if our plan value was only 33 crore rupees, they are saying we reject this plan since our claim of the 161 crore. I think Madan ji busy हो गए.
हाँ, सुन रहे हैं शर्मा जी, सुन रहे हैं. Please carry on.
हाँ, तो आर्गुमेंट में ये आया कि भाई हमारे पास कोई लिस्ट नहीं है एम्प्लॉइज की, तो उनसे पूछा गया कि भाई आप ये बताइए कि यदि प्लान की वैल्यू ओनली 33 करोड़ थी, उनसे पूछा गया कि भाई आप बताइए चलो आपको पैसा मिलता भी है, हम ये पैसा दिला देते हैं, तो हाउ यू डिस्ट्रीब्यूटेड, मतलब वी विल इनवाइट द क्लेम फ्रॉम द पब्लिक एंड okay, during the CIRP proceedings they have recovered 5 crore rupees, they have not distributed a single penny. On this count, since there is no provision of the payment of the entire dose of EPFO, plan was rejected and company went with the liquidation. This is a question from the bench and the judiciary. कौन आदमी होगा जो पे करेगा 33 करोड़ की फैक्ट्री के लिए 200 करोड़ रुपए पे करेगा, या उसकी कॉर्पोरेट डेटर की वर्थ ही 33 करोड़ रुपए है तो उसके लिए कोई 200 करोड़ करेगा? कंपनी लिक्विडेशन में चली गई. जुडिशियल ऑफिसर्स हैव नॉट अप्लाइड देयर माइंड कि दे डोंट हैव इवन ए लिस्ट ऑफ द एम्प्लॉइज, और इन देयर क्लेम इट्स आल्सो रिटन our claim is basis on their entire claim is the basis of the assumption and presumption that since company is running since 1995 and we hope that there is so much employee 400 because company have taken a loan of rupees 800 crore and it has a turnover, so it might be possible they are approx employees more than 1000 or they have assessed their dues. A company again, all the spirit of the IBC code have gone. कंपनी गॉन इन द लिक्विडेशन.
बदान सर, मेरे को थोड़ा सा परमिशन देंगे अगर मैं इसमें कुछ ऐड करना चाहूंगा, वाइटल समथिंग?
सर परमिशन तो हम आपसे मांगेंगे, आप थोड़ी
सर नहीं अभी आप इस समय आप होस्ट हो, हम मालिक हो, हम आपसे परमिशन लेके करेंगे. सर ये सर
इसमें फाइनल वर्ड मेरा होगा अभी.
सर वो तो हमेशा ही आपका फाइनल वर्ड होगा, इसमें क्या हर जगह होगा. उदिता जी देखो स्माइल करके, उनका और आप ही का दोनों का फाइनल वर्ड होगा. हम लोग तो आईपी हैं सर, एडवोकेट्स तो आप हैं. चलिए इन एनी केस सर ये मैं बताता हूँ. सर शर्मा जी मैं आपके फैक्ट को थोड़ा सा और ऐड करता हूँ. सेम सिचुएशन मेरे पास भी एक केस में है जिसमें मैं पहले आरपी था और अब लिक्विडेटर हूँ. ये जो ये इनकी थोड़ा सा मैं आपको फैक्ट्स बताना चाहता हूँ. ये लोग यानी कि फर्क कहाँ पे आया ये भी आपको बताता हूँ. ये व्हाट हैपेंड बेसिकली, जैसे इनके जो फैक्ट्स है ना, जो मेरे को लगता है सेम विल बी माय फैक्ट्स. व्हाट हैपेंड देयर इट वाज दैट कि इन्होंने क्या कहते हैं पीएफ अथॉरिटीज ने बैलेंस शीट्स उठा ली, आरओसी से जा कॉर्पोरेट डेटर से ले ली, वहां पे जितनी सैलरीज की फिगर आई थी उनको उठा लिया. पीएफ एक्ट के अंदर ना एक प्रोविजन होता है, मैं आपको कि जिसके अंदर ये प्रोविजन ये होता है कि अगर किसी बंदे के ऊपर, जैसे पहले लिमिट थी 15,000 रुपए की, आज की डेट में पहले 7,500 की लिमिट थी या 10,000 की थी, जो भी लिमिट थी, अगर उनके ऊपर ये पीएफ एप्लीकेबल ना हो तो उनको एक फॉर्म 11 या पता नहीं 16 करके कोई फॉर्म होता है, वो उनको देना होता है अथॉरिटीज को. अगर वो नहीं देते तो पीएफ अथॉरिटीज उनके ऊपर ड्यूज निकाल देती हैं. Same thing happened with me also, but in my case quantum was around 91 lakh rupees. उन्होंने मेरे को क्लेम फाइल करा, आई एम ए लिक्विडेटर एट पर्टिकुलर कंपनी, क्लेम फाइल करा. मैं अगर हुआ ना तो मैं आपके साथ भी को लेटर भी शेयर करूंगा. मैंने उनको उस लेटर के अंदर ये जवाब दिया कि जो हमारा सेक्शन है पर्टिकुलर पीएफ का, which says like that कि यानी कि पीएफ ड्यूज हैज प्रायोरिटी ओवर एवरीथिंग बिकॉज वी आर कीपिंग दैट मनी इन ट्रस्ट. तो मैंने कहा जी ये ट्रस्ट तब होता है जब हमने उनके एम्प्लॉइज के, देखिए पीएफ को हम दो तरह से पार्ट्स में डिवाइड करते हैं. एक ये है कि हमने एम्प्लॉइज की सैलरी में से पीएफ काटा और उसको जमा नहीं करवाया, और जब हमने काट के जमा नहीं करवाया देन वी आर होल्डिंग मनी इन ट्रस्ट. लेकिन अगर आप ऑन एड हॉक, देयर इज अ टेक्निकल वर्ड कॉल्ड एड हॉक, अगर आप एड हॉक बेसिस पे इस तरह की कोई डिमांड निकालते हो तो इट डजंट फॉल अंडर दैट पर्टिकुलर सेक्शन कि जिसमें उसकी पेमेंट प्रायोरिटी में है. इन दैट केस एट द मोस्ट इट कैन फॉल एज ए, जैसे गवर्नमेंट ड्यूज होते हैं ना, स्टैट्यूटरी ड्यूज होते हैं, जैसे टैक्स सेक्शन के अंदर जो यानी अभी हम लोग कस्टम की बात कर रहे थे, कोई चीज वायलेट कर दी, उन्होंने पेनल्टी लगा दी या कुछ और कर दिया, तो इट इज अ स्टैट्यूटरी ड्यूज, इट इज नॉट पीएफ ड्यूज. तो आई मेड अ डिस्टिंक्शन कि ये पीएफ ड्यूज नहीं है, दीज आर द स्टैट्यूटरी ड्यूज. ये आपकी सर नोडा अथॉरिटी ने मेरे को ये नोटिस इशू करा था, और कंपनी का नाम भी मैं आपको बता दूं, बेस्ट टेक्सटाइल लिमिटेड के केस में ये करा है. व्हेन आई गिव देम दिस कंप्रेसिव रिप्लाई, होगा तो मेरे पास रिप्लाई पड़ा होगा, मैं शेयर भी कर लूंगा यहाँ पे, बेनिफिट्स ऑफ एवरीबॉडी. दे केप्ट काम एंड टिल डेट दे आर कीपिंग काम. 6 महीने इस बात को हो गए हैं. हाँ, अगर ऑल ऑफ ए सडन उठ के दोबारा उन्होंने मेरे केस पिटीशन फाइल कर दी तो मेरी भी प्ली यही होगी कि दीज आर नॉट पीएफ ड्यूज, these are statutory dues. This is all I have to say.
एक मिनट मनोज जी, एक मिनट, एक तो नंबर वन आप कह रहे हो the PF you deducted from the salaries of the employees and you did not deposit that.
No, that was not the case. जो शर्मा जी ने केस बताया है उस केस में ये हुआ, उन्होंने मैं दोबारा पूरी बात बताता हूं, उन्होंने एड हॉक बेसिस पे बैलेंस शीट से फिगरें ली कि कितनी आपने सैलरीज पे करी हैं, उसके ऊपर जो असल में पीएफ पे करना था तो सिटी ने पे कर रखा था, लेकिन जिनके ऊपर ये पीएफ एप्लीकेबल नहीं था, लाइक जैसे 15,000 के ऊपर की जो सैलरी ले रहे हैं उनके ऊपर एप्लीकेबल नहीं था, लेकिन उसके लिए एक पर्टिकुलर फॉर्म जमा कराना होता है पीएफ अथॉरिटीज को, वो उन्होंने फॉर्म जमा नहीं करवाया, तो उन्होंने उसके ऊपर भी ड्यूज निकाल दिए बेस्ड ऑन दैट सैलरी। जैसे फॉर एग्जांपल अगर एक कंपनी की सैलरी के अंदर 1 करोड़ के करीब ड्यू आ रहा है, तो उन्होंने अपनी कैलकुलेशन करी कि इसका 10% 15% बनता है ड्यूज, 10 लाख रुपए ड्यूज निकाल दिया और उसको 5 से मल्टीप्लाई कर दिया और करके अलॉन्ग विद इंटरेस्ट एंड दिस एक इंस्पेक्टर रिपोर्ट लगाई और करके कर दिया। मैंने सर उनको पहला ऑब्जेक्शन ये रेज करा, आप मेरे को बताइए ये कौन से बेनिफिशियरी होंगे जिनको पीएफ पे करेगा, उनका आज तक कोई जॉब ही नहीं आया, और केस हो सकता है फाइल कर दे या ना करते मेरे को पता नहीं है, बट मैंने उनका क्लेम इस बेस पे रिजेक्ट कर दिया। दिस इज आई जस्ट एडेड विद शर्मा जी सेइंग।
मनोज जी हाइड्रो के केस में it is all in hydro case, it is on record, they have admitted that they don't have even name of single employee, no claim is received with them.
Same is with
they
me.
don't
Same
have
is with me.
Kailash, please mute yourself. Mr. Kailash, please mute yourself.
कर दिया, मैंने कर दिया म्यूट उनको।
But since there was a claim of the EPFO, our plan has been rejected and company went into the liquidation.
नहीं, अब मेरा ये मानना है
सर फाइनल वर्डिक्ट,
आपने जो एग्जांपल दिया, anything and everything payable to the employees, whether by your salaries or PF or ESA gratuity, either it can be employees dues or not employees dues. These can never be statutory dues.
I differ, sir. Absolutely differ.
You may differ. You may differ. You have all the right to differ, sir.
Sir,
हम तो कोर्ट में जाते ही सोच के ही जाते हैं कि सामने वाला एडवोकेट तो डिफर करेगा, मजा तो तभी आएगा आर्गुमेंट्स में।
सर बिकॉज़ दीस आर नॉट पेबल टू एम्प्लॉइज।
आज का ये मौका नहीं है इसके ऊपर हम करें।
Sir, I am sure if, sir, I am sure.
Just a minute. Secondly, मेरे केस में और क्या हुआ है, पीएफ डिपार्टमेंट ने डिमांड अपने फाइल की, क्लेम फाइल किया, सपोर्ट 10 CR का। This 10 CR includes provident fund account amount, interest, penalties, everything. आरपी ने 50%, आरपी ने एडमिट कर लिया पूरा का पूरा। नाउ जो रेजोल्यूशन प्लान आया, रेजोल्यूशन प्लान में 50% ऑफ पेमेंट हैज बीन प्रोवाइडेड टू पीएफ डिपार्टमेंट एंड द प्लान स्टैंड्स अप्रूव्ड बाय एडजुडिकेटिंग अथॉरिटी। नाउ दिस पीएफ डिपार्टमेंट प्रेफर्ड एन अपील before NCLAT. NCLAT has passed an order in favor of the PF department that entire amount, including this damages and interest, has to be paid.
Sir, Jet Airways also says the same.
Udita, abhi I'm coming to
Asante, there are so many judgments now. After in last 3-4 months, there are so many judgments on this point.
Sharma ji,
Mamta ji, you are quite experienced in Jet Airways.
Yeah.
Sir, sun to lo, please, last sun to lo. Now, against this order, I have preferred an appeal before Supreme Court just before this vacation. I'm pretty sure अगले 2-3 महीने में इसके ऊपर हमें clarity मिलेगी.
Sir, I'm sure.
बट मेरा सिंपली मानना है, सपोज उसका 10 करोड़ का क्लेम है पीएफ डिपार्टमेंट का, अगर 10 करोड़ का पूरा एडमिट कर लूं, दिस प्लान इज नॉट वायबल फॉर मी, एंड इफ सपोज आई प्रोवाइड एंटायर 10 CR फॉर पीएफ डिपार्टमेंट, सीओसी विल नॉट अप्रूव दिस प्लान। सीओसी कहेगी उन्हें दे दो ना सारा, मुझे क्यों दे रहे हो, फिर मैं आई डोंट अप्रूव द प्लान। तो अकॉर्डिंग टू मी दिस appellate tribunal's judgment is flawed, that you provide 100% to the PF department.
हम भी पीछे आ रहे हैं सुप्रीम कोर्ट एनसीएलटी से रिजेक्ट करा के।
आपके पीछे टाइम तो इम्प्लीमेंट एप्लीकेशन डाल दिया, मेरे जैसे पार्टी बन जाइएगा।
अब हम अपील फाइल करने वाले हैं 1-2 दिन में।
सर
भाई देखो, मेरा जो है क्वेश्चन ये है कि जुडिशियल अथॉरिटी दे आर नॉट टेकिंग द कॉग्निजेंस द क्लियर कट एडमिशन के दे डोंट हैव एनी जो है लिस्ट ऑफ एम्प्लॉइज टू whom they have distributed this money.
Mr. Raju,
he asked the question.
Mr. Raju, Raju.
Sir, we are in the 6th year of after introduction of the IBC. I think in almost 99.9% cases of admitted cases, there will be issue of PF claims dues by the PF. Invariably, in every company, there will be either EPF or contributory potential, whatever it is. So this single issue remains unsettled for even after 6th year. How can we expect a reasonable or a meaningful resolution? How can an investor come with confidence if the single issue cannot be resolved even after 6 years? So in every case, this will be haunting of the investors. They are afraid of what will happen after that. So that is why this is the basic issue of why investors are reluctant to come with meaningful resolution. Because this is an issue applicable for all the cases. 99.9 cases PF dues will be there. So that issue remains to be resolved till now. A finality has to come.
Rajuji, thank you very much. We are a little bit short of time.
Sir, one more, just to add one thing only, sir.
Sir, final verdict
value is lower than the PF claim, then what will happen in that scenario?
That's what the question I raised.
Yes,
yes. This is what Mr. Sharma also said. Mr. Sharma said the same thing.
Yes,
in our case, in their case, their application, it is written that we have the tentative claim. What? Kindly go to on the word. Tentative claim of 161 crore along with the interest. So they are saying that now our claim amount is more than 300 crore. Plan value is 33 crore. Liquidation value is 26 crore.
So in the liquidation, you can distribute the asset to the EPF authority and ask them to take realization. That's it.
अच्छा मनोज जी हमारा फाइनल वर्ड ये है
सर एक सेकंड मैं आपको एक सेकंड के लिए रोकूंगा आई एम रियली सॉरी ममताज इज डीलिंग विद जेट एयरवेज यू नो एज ए इन अ वेरी हाई कैपेसिटी तो जेट एयरवेज में पीएफ का इशू 450-500 करोड़ रुपए का आया था तो ममता जी ये हम लोग डिस्कस कर रहे थे कि पीएफ ड्यूज के ऊपर लॉट ऑफ यू नो लॉट ऑफ जुडिशरी इज देयर लॉट ऑफ थिंग्स आर देयर आपका इसमें क्या ओपिनियन है बिफोर वी टेक फाइनल वर्डिंग फ्रॉम द मिस्टर वेदांत सर
Yes. I just, in short, let me tell you what is happening in few of the matters is the lawmaker, I mean, the judiciary is saying that not only the principal, even the penalty, that is 7Q and 14B, 14A, 14B, 7Q, all has a priority. You will now see that few of the resolution plans were saying, okay, the principal, let it be paid on priority in full. But now the problem that we've encountered with even the penalty and the damages and the interest will also have to be being paid in full. So Mr. Raju's fear is right that you're always looming large and the amount is also not finalized. The verdict is not there. They just say that iske andar jo bhi penalty hai, interest hai, wo sab aapko lagega. So we are still encountered with that pain. A lot of the matters are pending in the courts.
But court को ये समझ नहीं आ रहा है कि if everything is provided, this plan will never get approval of the COC.
You are right. Absolutely.
No plan will be approved in this scenario. No plan will be approved.
Udita ji, what you would like to say, please?
Sir, I also think a very different perspective to all this is that this is somehow giving a leeway to the ex-management also. So till we did not have Jet Airways and all these latest judgments, the law was that if there is a PF fund which has funds, then of course the company will be liable, the corporate debtor will be liable. But if not, then the company or the liquidator RP cannot be liable. So then the PF authorities had to chase the ex-management to recover their dues because it was their responsibility to ultimately pay to the employees, etc. But now I think with this judgment that everything has to be paid. So if let's say in a case everything is paid by the corporate debtor or by the new RA, then the ex-management has no responsibility at all. So I think this is also giving a leeway to the ex-management in a sense.
I think Udita, you are talking about provident fund. No,
yes,
PF,
sir. Yes, sir.
PF fund is on a different footing.
So even EPFO. All these dues because all these laws provide for the penalty of the management. But now if the dues are being recovered, then the ex-management will not be liable in any manner. So I think this is also, the courts can also have a look at this, that ultimately it was the responsibility of the earlier management to make sure that whatever you're deducting from the employees or not deducting or you are responsible to pay is being deposited in their accounts. but that is not being done. So I think the ex-management will be the most happiest with the judgments which are coming recently.
What is the scenario where no PF is deducted, there is no PF fund, and
yes.
the company under CIR?
मनोज जी, मेरी सलाह ये है कि आप एक ना सेपरेट वेबिनार करिए
इसमें एक सेपरेट वेबिनार करिए,
treatment of employees dues and treatment of statutory dues in a resolution plan.
सर बिल्कुल ठीक बात करते हैं सर, आप प्लीज अपनी फाइनल वर्डिंग दीजिए। हमने
तो
और भी आपसे
मेरे फाइनल एडवाइजरी आ गई, बस आगे चले हम। क्योंकि फाइनल एडवाइजरी के लिए तो मैंने खुद ही अपील फाइल की है सुप्रीम कोर्ट में, वेटिंग फॉर फाइनल वर्ड फ्रॉम द
चलिए ठीक है। लेकिन सर मैं अपने आईपी ब्रदर्स को लास्ट में ये कहना चाहूंगा, हो सकता है मैं गलत हूं, बट आफ्टर लॉट ऑफ एनालिसिस, अगर तो पीएफ काट के जमा नहीं करवाया, देन आई ट्रीट इट एज अ पीएफ ड्यूज, हैज प्रायोरिटी एज पर द रेलेवेंट सेक्शन। लेकिन इफ एनी अदर पीएफ ड्यूज आर देयर, जो कि यानी कि जो इन फॉर्म्स ऑफ पेनल्टीज हैं, या इन फॉर्म ऑफ, जैसे शर्मा सर ने बताया कि एस्टिमेटेड बेस पे जिसमें एम्प्लॉइज का कोई नाम नहीं है, आई एम रिजेक्टिंग। मे बी कल को कोर्ट एनसीएलटी मेरे को रिजेक्ट कर दे एज एन आईपी, वो एक अलग इशू है, लेकिन एट दिस मोमेंट आई एम रिजेक्टिंग। थैंक यू वेरी मच सर, प्लीज कैरी ऑन।
मेरे केस में अगर मान लो यहाँ पे प्लान अटका है सीओसी से, so should we do something because they will not approve as you said? So as a IP can we do, because our responsibility is that the plan should get through in case the liquidation plan is more than the liquidation value. That's what I just thought. I just checked.
मैंने केस में भी क्या किया है प्रशांत जी, मैंने केस में भी क्या किया है, they are also the provident fund has actually they filed a claim after the approval of the plan by COC. So certainly RP rejected the claim. Now they come before adjudicating authority. Adjudicating authority, as usual, they are labor friendly and employees friendly. Now they are asking RA, why don't you consider something?
Sir, that they are not labor friendly. They are not employee friendly.
Sir, एक minute.
They want to demonstrate.
Please let me complete my sentence. Let me complete my sentence.
Sorry.
So what there, I have given a proposal to the adjudicating authority in consultation with the SRA, that we are ready to give whatever the principal amount is due to the employees, and we will deposit this amount directly to the bank accounts of the employees and workers. We will not give a single penny to PF department, because tomorrow if we give to them, they may adjust it against interest and penalties. We will give everything to the employees and workers. We will deposit in their account, but no interest and damages shall be paid. And adjudicator is actually considering this. उन्हें समझ आ गया कि हम क्या कह रहे हैं और क्या कहना चाह रहे हैं. So we may get some order after the vacation. I may get some order with this respect from the principal bench itself. तो प्रशांत जी, आप ऐसे ही कुछ प्रपोजल दे सकते हैं सीओसी को और एसआरए को.
पर सर सीओसी अप्रूव नहीं करेगी ना, क्योंकि उसमें यही बोलेगा कि भैया अगर मान लो ये नहीं हुआ तो पूरा पैसा तो वो ले जाएंगे, हमको तो फिर कुछ नहीं मिलेगा.
ये पूरे की बात मत करो ना, प्रिंसिपल की बात कैलकुलेट करके देखो ना कितना बनता है.
सर तो भी वो लिक्विडेशन वैल्यू से नीचे ही बनता है, मतलब ऊपर ही बनता है. सॉरी,
फिर लिक्विडेशन हो जाने दो.
यस सर, मुझे भी वही लगता है.
ठीक है, चलो ओके. नेक्स्ट केस इज Vallal RCK versus Shiva Industries. I'm not going into the facts of the case. Let me go to the issue only. Can the adjudicating authority or appellate authority hear an appeal regarding the commercial wisdom of the creditors committee? No doubt we have so many judgments on this, Maharashtra Seamless, case Sasidhar, SR Steel. But इसके facts पे आना पड़ेगा. इसके facts बड़े interesting है. Here is not the case of approval of resolution plan. Here it's a case of approval of a settlement plan. Actually, क्या company filed a liquidation application. RP filed a liquidation application. In the meantime, now a settlement proposal is there, and COC with 94% authority voting share approves this settlement plan. Now this settlement plan is placed before the adjudicating authority and 12-way application is preferred. NCLT क्या बोलती है? This is not a settlement plan. This is a business restructuring plan. We do not entertain this settlement plan. Therefore, we are rejecting this 12-way application, and now we are passing a direction to liquidate the corporated. Against this order, an appeal is preferred before NCLAT. NCLAT also upholds the order passed by the adjudicating authority. And now the matter comes before Supreme Court. And that is why this question is there now. Can the adjudicating authority or appellate authority hear an appeal regarding the commercial wisdom of creditors committee? Because here COC has approved a settlement plan and an application under 12A has been filed. NCLT says, sorry, this is not a settlement plan. This is a business restructuring plan. We are rejecting 12A. We are passing a liquidation order. Supreme Court says, when 90% or more of the creditors in their wisdom, after due deliberations, they find that it will be in the interest of all the stakeholders to permit a settlement and withdrawal of CIRP, in our view, the adjudicating authority or appellate authority cannot sit in an appeal over the commercial wisdom of COC. The interference would be warranted only when the adjudicating authority or the appellate authority finds the decision of the COC to be capricious, arbitrary, irrational, and dehorse the provisions of the statute of the rules. Or the rules, it should be or the rules. So therefore, Supreme Court decided, COC has decided, accepted the settlement, adjudicating authority has to approve this 12A application. But I want to have a discussion with all of you. In my opinion, for 12A, no settlement is required. Because section 12A does not talk about the word settlement. It simply talks about withdrawal of the application with voting of 90% of voting share of COC. If COC decides with 90% majority, whether there is settlement or not, COC can decide without settlement also. Settlement is not mandatory, it's not necessary, it's not a prerequisite. Here you have settlement, here you have 12A application, here you have 90% voting, still adjudicating authority says, sorry, no, CDC to be liquidated. Ultimately, Supreme Court came to the rescue of the corporate debtor and decided that 12A should be heard and should be decided. Any view on this? Because in 12A, many of the participants...
One view, don't say rescue of the corporate debtor, also say rescue of the COC.
Absolutely, yes.
सर जैसे आपने अभी ये एक केस बताया, सेम एक केस के अंदर very recently, hardly I think last week only, what happened that जो particular एक आरपी था, उसकी रजिस्ट्रेशन आईबीबीआई ने कैंसिल कर दी. जब आईबीबीआई ने रजिस्ट्रेशन कैंसिल कर दी, वो नेम द नेम ऑफ द केस एंड द नेम ऑफ द आरपी, तो एक वैक्यूम क्रिएट हो गया कि अब आरपी नहीं है उसके अंदर. तो दिल्ली हाई कोर्ट में भी कुछ मैटर चल रहा था, उन्होंने डायरेक्शन दी कि अब इमीडिएटली सीओसी को डायरेक्शन दी कि अब सीओसी इमीडिएटली आरपी को मिलके अपॉइंट करे. सीओसी ने मिलके एक आरपी को अपॉइंट करा, वेयर दे वर हैविंग मोर देन 90-95% वोटिंग. प्रपोजल बेसिकली लेके गए एनसीएलटी के पास कि हम इस पर्टिकुलर आरपी का नाम प्रपोज कर रहे हैं, तो वी हियर बाय रिक्वेस्ट यू टू कंफर्म आवर अपॉइंटमेंट, समथिंग लाइक दैट. NCLT went against it. He says कि I would like to maintain the independence. जो आप कह रहे हैं मैं उसको अपॉइंट नहीं करती, मैं अपने पैनल में से अपॉइंट करके कर रही हूँ. कहने का मतलब यह है कि NCLT अब इनकी विजडम के अंदर, या उसके बाद NCLT की इनकी विजडम के अंदर ये कैसे डिसीजन लेते हैं, क्या डिसीजन लेते हैं. सर आप लोग ज्यादा फेस करते हैं, तो हम लोग तो इक्का दुक्का कुछ केसेस ज्यादा फेस कर रहे हैं. दिस इज आल्सो क्रिएटिंग लॉट ऑफ आर्बिट्रेरीनेस.
मनोज जी, आपके फैक्ट्स पूरे नहीं है. मैं आपको कंपनी का नाम भी बता देता हूँ, सीओसी.
सर मैं बताना नहीं चाहता था,
आरपी का नाम भी बता देता हूँ. जो आप केस कह रहे हैं, इस केस में वन ऑफ द members of the COC proposed a name. The other COC member opposed it before NCLT that this name should be decided and approved at the meeting of the COC, but there is no COC meeting. So the largest shareholder is taking a call. And therefore, the NCLT has decided, yes, this matter has to be discussed at the COC meeting. Go to COC meeting, pass a resolution, then come back to us. And if you cannot do that, then we will pass somebody from the panel. To this, the financial creditor agreed, and ultimately Supreme Court ने in the meantime किसी को commissioner appoint कर दिया है. वो भी मुझे मालूम है किसको commissioner appoint किया है. Under his supervision, the COC meeting shall be called and COC decision shall be forwarded to NCLT. So there is nothing wrong in this.
नहीं सर, आपका केस डिफरेंट है, मेरा केस डिफरेंट है, एब्सोल्युटली डिफरेंट है.
चलो ऑफलाइन डिस्कस करेंगे दोनों.
करेंगे पक्का सर. डिफरेंट आपका केस, मेरा केस. इस केस में ये लास्ट वीक में हियरिंग हुई थी एनसीएलटी में, कोई कमिश्नर अपॉइंट नहीं हुआ. तो
उसी की बात कर रहा हूँ मैं, उसी की बात कर रहा हूँ. प्लीज, मैं भी उसी की बात कर रहा हूँ. मैं हाईकोर्ट का भी नाम बता सकता हूँ, जस्टिस यशवंत वर्मा के पास लगा हुआ था.
चलिए, ओके,
चलो
ऑफलाइन बात करेंगे. ठीक
है, डन. सुनील नायर जी कुछ कहना चाह रहे हैं या उन्होंने अनम्यूट कर लिया अपने आप को? ओके. Kotak Mahindra Bank versus A. Balakrishnan and others. This case has been decided on 30th of May 2022. The issue involved in this is that there is a recovery certificate granted by Debt Recovery Tribunal. So whether the recovery certificate granted by DRT, is it a financial debt in terms of section 5(8) of IBC? And consequently, whether the holder of the recovery certificate is a financial creditor. And third question is, does the DRT's issuance of recovery certificate create a new cause of action and timeline for the purpose of initiating CIRP for the purposes of limitation? Now, Supreme Court has decided all the three answers to all these three questions are in yes. Yes, this recovery certificate is a financial debt. The holder of recovery certificate is a financial creditor. And yes, this issuance of recovery certificate creates a new cause of action and the limitation period will start from this date of issuance of recovery certificate. Even though the earlier limitation already expired, but the new limitation will start from this date. IOB versus RCM infrastructure, again decided on 18th May 2022. The issue involved is whether security realization by a financial creditor. तो इसके फैक्ट्स पे आते हैं. बड़ा इंटरेस्टिंग केस है ये, हम कई लोग को फेस करते होंगे. What has happened in this case? The CD has failed to repay the loans. Now the bank, in exercise of its powers under SARFAESI, auctioned the assets of the CD through e-auction. अभी CIRP start नहीं हुआ. This is prior to CIRP. अब एसेट बिक रही है और पेमेंट हो रही है. फाइनल सेल सर्टिफिकेट इज येट टू बी इशूड, फाइनल पेमेंट इज येट टू बी मेड. इन द मीन टाइम, an application is preferred before NCLT. Application is admitted and CIRP commences and moratorium declared. Now, subsequent to an application made by the promoter of the CD, he challenges the impugned transaction under SARFAESI by the bank and sale of property of the CD. He says the sale should be set aside because the sale certificate is yet to be issued, final payment is yet to be made. Now the moratorium is there, nothing can move. NCLT decides in favor of the director of the corporate debtor and set aside the sale of property by the bank. अब ultimately question क्या है सुप्रीम कोर्ट के सामने? Whether the security realization by an NFC who received part payment from the purchaser of the corporate debtor's property under SARFAESI prior to commencement of CIRP, can it be resumed after the initiation of CIRP and declaration of moratorium? Supreme Court has decided that because the sale in this case is governed by Rule 8 and 9 of SARFAESI rules, sale will be considered completed only when auction purchaser makes the entire payment and the authorized officer issues a certificate of sale. The purchaser made a partial payment in this case and no sale certificate has been issued on the date of admission of CIRP. As a result, because this entire transaction is barred by section 14 of the code, financial creditor cannot continue the proceedings under SARFAESI once the CIRP has commenced and the moratorium has been ordered. Now, this is a peculiar situation, but for RPs, it is very handy judgment. Mamta, you want to say something
Yeah,
on
even
this?
I have handled several cases like this. This
Yes.
is the judgment that is being given.
No, in your case also, whether the entire sale transaction was set aside?
Yes, yes. Actually, they said that like a certificate of incorporation, while in case of making a company is conclusive evidence, everything you do, sales certificate is a conclusive evidence. So unless the sales certificate is issued, every transaction is incomplete.
So it
And so
means amount has to be refunded. Whatever the amount has been received,
yes, amount has to be
refunded from the purchaser.
Correct.
Sunil Kumar Jain and others versus Sundaresh Bhatt.
Probably that was the handiwork of the corporate debtor to stall the proceedings of SURFACE and involved in the entire episode of CIRP only. Is it possible, sir?
Everything is possible in India. Everything is possible.
So the bank should not get any paisa out of it. So they have stopped everything.
इसको मैं क्योंकि मनोज जी मैं इस क्वेश्चन को इस केस को मैं अभी स्किप कर रहा हूं because as we have discussed that we will have a separate webinar on all employees dues, labor dues and statutory dues. This is concerning that only. तो मैं इसको skip कर रहा हूं for the time being. Okay. Now here in this case, what Supreme Court had decided that in case of section 9, to fit in the definition of operational creditor or operational debt, what actually the law says, there should be a sale of goods or provision of services or employees dues or government dues. These four categories are there in the operational debt. But wherever some security deposit has been given, that does not form part of any of these four. That's not covered by operational debt. So here there was a question of some security deposit. Ultimately, there's a default on the part of the corporate debtor. Application is preferred. CD says it's not an operational debt. Now matter goes to Supreme Court. And Supreme Court decides. The issue is whether the term operational creditor refers only to those who provide goods or services to a corporate debtor and does not include who receive goods or services from the corporate debtor and provide a security deposit. Supreme Court says, actually this was a gray area abhi tak, but Supreme Court now has provided a clarity. Supreme Court says as per section 5 subsection 21 which defines operational debt. It's a claim for the provision of goods or services, including employment and blah, blah. If you come to the second sentence in the fourth line. In the present case, the Supreme Court interpreted the phrase in respect of. If you read section 5 subsection 21, it is written there in respect of provision of goods and services. What Supreme Court interpreted, this security is also in respect of sale of goods and services. So there need not be a sale. Suppose I am a purchaser. I am purchaser, I purchase the goods. And so on the other end is a seller. And while purchasing the goods, I have given some security deposit. सामने वाला security deposit वापस नहीं करता. Can I, being a purchaser of goods, file a case against him under section 9? If you read the plain definition of operational debt, it's not covered there. Because I have not sold the shares, I have not sold the goods, I have purchased the goods. But Supreme Court says this security deposit is with respect to sale of goods. So therefore, this deposit of security deposit is also part of operational debt. It is an operational debt. And the person who has given it becomes an operational creditor. Therefore, this application.
Sir, I have a doubt here. Will such transaction not be covered under commercial effect of borrowing in the definition of financial debt?
I'll say no.
Okay.
My answer will be no. Well, I'm very clear it cannot become a financial debt. It can be, at the most, it can become an operational debt, which the Supreme Court has clarified.
I understand the logic behind it because ultimately the genesis is the sale and purchase of goods. That I understand. But giving an advance to somebody Even if it is for the supply of goods which I want. I understand it is not for the purpose of financing the business also. But then what exactly is the gambit of when we say commercial effect of borrowing? What is covered in that?
एक काम करते हैं ना 5-8 को फिर से पढ़ते हैं एक बार and let's discuss it offline.
ठीक है सर, डन.
सर इसमें एक थोड़ा सा लाइटर नोट कर दीजिए, in the case of rent, because that thing is also, you know, do keep in how it will qualify, or it will qualify or it will not qualify as operational debt.
मेरा मानना है qualifies because there is a provision of services. There are services.
Okay, in that case, landlord can file application subject to for Section 4 limitation against that particular city.
GST में भी G लगता है इसके ऊपर. It's treated as service there.
So GST में treated है, you know.
Service है ना, तो यहाँ भी इसकी service है ये. This is a service.
Okay, sir. ठीक है. Fair enough.
Okay. TCS versus Vishal Gishulal Jain. The issue involved is whether can NCLT use its residuary powers under Section 60 subsection 5 clause C to resolve the contractual dispute between the parties, and then can it impose an ad interim stay on the termination of the facilities agreement in the exercise of such residuary jurisdiction. Supreme Court has very categorically said, and under Section 65C, NCLT cannot use its power to resolve a contractual disagreement between the parties. Since the intervention of NCLT and NCLT cannot be characterized as a rewriting of the parties' contract, in the lack of such jurisdiction, the NCLT cannot impose ad interim stay on the termination notice. अभी एक और केस में आज सुबह पढ़ रहा था, that was with respect to appointment of a mediator by NCLT under Section 442 of the Companies Act. मतलब application is there, application is pending before adjudicating authorities under Section 7 or 9. Now the adjudicating authority says, okay, we appoint an arbiter, we appoint a mediator under Section 442 of Companies Act. Ultimately decided by NCLAT, sorry. Here you are adjudicating authority. 442 deals with tribunal. You are not a tribunal under IBC. Here you are adjudicating authority. You cannot use your power. You have to say yes or no to the admission. You cannot mediate. No doubt informally NCLT mediates also, because whenever somebody asks for time, कि सेटलमेंट हो रही है, टाइम दे दो, दैट्स नथिंग बट मीडिएशन आल्सो. मुझे बताओ, तो वहां पे सुप्रीम कोर्ट भी दोनों लॉयर्स को भी बोलती है, प्लीज व्हाई डोंट यू इंटरवीन. दैट नेवर बिकम्स पार्ट ऑफ द ऑर्डर. Indirectly that is advisory, and in majority of the cases that is followed, and majority of the cases I have seen settlement happens. But officially NCLT cannot mediate or cannot appoint a mediator or conciliator or arbitrator. Base realtors versus Grand Realcon, the issue involved is, the issue is at the bottom of this slide. Whether an application under Section 7 of the code can be submitted. अब ये केस के डिसीजन कब है NCLAT से, on 15th November only, last month. Whether an application under Section 7 of the code can be submitted and maintained for the component of interest only that became due and payable without requesting the principal amount that has not yet become due and payable. तो अगर interest amount 1 crore से ऊपर हो गया है, that has not been paid, can an application under Section 7 be filed or not? Answer is yes. It's not necessary that the principal should have become due and payable, even though interest has become due and payable and it falls within the threshold limit of Section 4, the application can be admitted. Ashok Kumar Tyagi versus UCO Bank. Whether the corporate debtor is entitled to be restored and be permitted to function as it was functioning prior to CIRP. ये भी बड़ा इंटरेस्टिंग केस है यहाँ पे. COC पे स्टे भी लग गया है अब साथ में क्लैरिटी नहीं है कि who will run the affairs of the corporate debt, और ये बड़ा कॉमन है हम सबके सामने. This is very common problem कि NCLAT स्टे करती है without giving any directions कि ना who will run the affairs of the corporate debtor, whether IRP or RP. अगर RP ने रन करने हैं तो RP can take a call after having permission from COC under 28(1). COC is not there. Can he take all the decisions of its own? So here what has happened actually, NCLAT has held that once the order admitting CRP has been stayed, the IRP is not entitled to discharge any function, and that a CD also cannot be restored as it was functioning prior to admission of Section 7. Reliance was placed in this case on Shri Chamundi Mopeds Limited, passed by Honorable Supreme Court. However, to ensure that day-to-day functioning of the CD as a going concern, the court allowed the CEO of the corporate debtor, authorized to operate the bank accounts, to make payment of wages to workers, workmen and employees, subject to the submission of all details of expenditure on a weekly basis to the IRP. उसको खाली information supply करनी है, बाकी काम वो खुद करेगा. But I fail to understand what will happen to the rest of the activities. Payment of salary value तो हो गया. Going concern में तो number of other decisions are to be taken. Actually, on this case, I think मैंने एक बार सोचा हुआ कि 1-to-1 मीटिंग करेंगे हम NCLAT members and chairperson के साथ. मनोज जी एक डेलीगेशन लेकर जाते हैं कि जब जब स्टे लगता है, whether stay on the constitution of COC or stay on CIRP or status quo order is passed, clear-cut direction should be issued that who will run the affairs of the corporate debtor, who can take the decisions, who can release the payments, and what shall be the remuneration of IRP or RP during this period. That should also be decided. That should also be part of the order. Actually, that remains in limbo always. And later on, fresh applications are filed for this purpose only, that remuneration of IRP, RP should be given for this period. I think this was the last from my side. Now, house is open. If anybody else wants to share anything or to discuss any other issue. Cases तो मेरे पास बड़े सारे थे, but मैंने time देखा, मनोज जी ने time कितना allot किया, और फिर भी I think I've exceeded my time. So I want to hear others also, including especially Mamta ji. I request everybody to please keep your videos on now. जो फॉर्मल ड्रेस में बैठे हैं वो तो ओपन कर ही लें.
I must say these presentations are actually quite important, because in day-to-day working we tend to kind of not brush up so much. We think we'll do it. For example, the NPA judgment of the NCLAT Delhi bench was very important, where it said NPA date is not important, the date of default is important. Now we knew it, but somewhere or the other, it just gets brushed under the carpet. I'm sure, gentlemen, you may we have to thank Mr. Madan for a very extensive presentation. Devil lies in the details, and he makes sure to bring out the details on the surface. And I think a very important judgment was also given by, in this Kalinga Allied Industries matter. You may have seen it in the matter of, I think, Bindal Sponge, where it said that after 3 years or 2.5 years, the COC wanted to again renegotiate or went into new negotiation because somebody else was offering a very good money. So the Honorable NCLAT said that that is not possible. Everything has a time foundation, and IBC is all about time boundaries. So somewhere or the other, though we are getting conflicting judgments, but one thing is coming out for sure, that it is a time-driven law, and that is quite tight. That is quite coming well. So any questions, if any observations, anything has anyone to say, then we'll take it up with our speaker.
Or any experience sharing also.
Absolutely. But first, iron out your creases. Because
Madanji, yes.
Haji Joginder ji, please.
Yes, certainly. In case of Rainbow, if in the when the company is under liquidation and the statutory authority has filed the claim as a operational creditors, before coming the judgment of Rainbow by the Supreme Court, whether the liquidator has to continue them as a operational creditor, or they are to be considered as a stored creditor as per the judgment, because they have not filed any. They have not given the
link missing है. आपका एक link missing है. 53 deals with operational creditor. 53 does not say secured financial creditor. 53 deals with secured creditor.
Proportionately amount is to be given as per the judgment.
53 deals with secured creditor. Secured creditor may be financial creditor or operational creditor. If somebody has filed a claim as operational creditor, and if they are secured operational creditor, they will be at the top.
They have not claimed as a secured creditor.
So if they are not,
because
they are not.
As per the Rainbow judgment, there must be any clause in their act, in the Commercial Tax Act, that their dues are secured. Unless they are claiming as a secured, but is to be treated them.
देखिए जिस समय आपकी SCC बनेगी ना,
SCC बन चुका.
सुनिए मेरी बात. At that point of time, it will be clarified by you that who is secured and who is unsecured, who is FC, who is OC. If they are aggrieved with your decision at that point of time, let them go to adjudicating authority and file an application. So before you realize the assets and distribute the assets, तब तक adjudicate authority decision आ चुका होगा. आप वो करिए जो आपके रिकॉर्ड्स के हिसाब से, नॉट एज पर रेनबो.
रिकॉर्ड के हिसाब से ही कर रहा है ना. जब तक वो अपने आप को क्लेम नहीं करते,
आप रेनबो की इंटरप्रिटेशन मत करिए अपने.
इंटरप्रिटेशन नहीं कर रहे हैं उसको, एज इट इज चलने दें उसको, क्योंकि उन्होंने भी हमारे को कोई सिक्योर्ड का क्लेम फाइल नहीं किया.
और उन्हें रेनबो की प्रोटेक्शन चाहिए. लेट देम गो टू एडजुडिकेटिंग अथॉरिटी.
दे हैव टू गो एडजुडिकेटिंग अथॉरिटी.
यू डोंट फाइल एन एप्लीकेशन. कई बार हो जाते हैं. लेट मी सीक ए क्लैरिफिकेशन.
नहीं, दैट इज करेक्ट. वी हैव नॉट टू सीक एनी क्लैरिफिकेशन फ्रॉम ए. ओके, थैंक्स.
Yes, Mr. Joy wants to say something.
Now, Madam, as far as the EPF it is concerned, see, in every claim, there is a component of the employee dues. Then, as all rightly said, there is interest component, penalty component. Of all these charges, it applies. Can we take a stand that, in the sense, as far as the employees' dues are concerned, let us say it is payable to the employees. The other component, it is the government dues.
I don't think, sir, you can take that view.
In fact, I have taken the same view what you were saying, but मदान सर ने उसको एकदम neglect कर दिया और ममता जी भी उसको neglect कर रही हैं. It means that their view shall prevail, and we both should respect their view because we both are IP and they both are advocate.
But in practical cases, they are acting as super bosses.
मदान सर, एक मेरा क्वेश्चन और है. ये सुंदरेश भट्ट वर्सेस सेंट्रल एक्साइज कस्टम ड्यूटी. In that matter, if the custom duty is not to be paid, they have to file the claim. But would be the treatment of GST on the goods which are lying in the custom bonded warehouse? They are to be treated as they have to file the claim, or we have to consider, or they can charge the GST at the time of relief of the goods from the custom duty.
Only one thing I can say, Mr. Madan, that here Rainbow will not be applicable. That much clarity I have.
Sundaresh Bhatt का बात कर रहा हूँ मैं.
Get applicable in GST. That much clarity I think I have.
Yeah. Actually, at least एक point बताओ मेरे साथ हुआ है, मैं भी यही कह रहा हूँ. It won't be applicable because a lot of, if we analyze Rainbow, इसके अंदर बहुत सारे चीजें हैं. VAT हो गया, उसका क्या कहते हैं, वो उसके ऊपर क्लेम फाइल करा और प्रॉपर्टी को अटैच करा. These attachment power GST के अंदर है या नहीं है, इसके ऊपर भी एक बड़ा डिबेटेबल क्वेश्चन है. तो considering all these things, whether that is secured or not, at least चलिए ममता जी एक तरफ तो मेरे पास आए. थैंक यू वेरी मच. हाँ जी, जोगिंदर जी का क्वेश्चन है जीएसटी के ऊपर कि अगर जो कस्टम वाले, तो मदान जी प्लीज आंसर हिज क्वेश्चन.
सुंदरेश भट्ट जिसमें कस्टम को तो उन्होंने अवॉइड किया है कि कस्टम अथॉरिटी वाज डायरेक्टेड टू रिलीव द गुड्स without receiving any dues. They have to file the claim only. If the GST is to be payable or at the time of relief of the goods, whether the GST department can claim the GST is to be paid at the time of relief of the dues, or they have to file the claim with the liquidator.
अब आपका अगर इस क्वेश्चन को मैं इंटरप्रेट करूं, at the time of commencement of CIRP, the goods are in the warehouse of the custom department.
Now, before commencement of CIRP, goods are lying in the custom department.
That's what I'm saying. मैं भी वही कह रहा हूं. At the time of
अभी उनसे के पास ही है, before CIRP.
Sir, you please allow me.
Yeah, please, sir.
At the time of commencement of CIRP, the goods are lying in the warehouse of the custom department.
Yes, sir. Goods are lying in the custom department before commencement of CIRP.
Sir, please allow me to complete, Yogendraji, please.
Yeah, yes. Sorry.
Now, at that point of time, if GST department is of the view that tomorrow when these goods will be released, the GST will be payable.
Yeah.
On that hypothetical scenario, they may think of filing a claim. Let IRP take a call on that. Now, second question is, during CIRP period, say as per the directions of the court, these goods are released. And the moment the goods are released, according to you, GST becomes payable.
Yes.
That may be another scenario. So whether at this point of time, this GST will be considered a CIRP cost or liquidation cost if they are released during liquidation. I think we need to read this case as per the facts and circumstances of each case. What is the date on that application, or what is that particular date, on what conditions the goods are being released, whether GST is required to be paid, whether GST is payable or not, whether GST authorities are intervening at all.
Sir, will you allow me to clarify it on it?
Sir,
कस्टम से हम लोग परचेज करते हैं. जब परचेज करते हैं तो हमारे पे जीएसटी का कुछ नहीं आता. हम जब उन गुड्स को सेल करेंगे, when we will sell those goods, only at that time GST liability will come out to be there. It has nothing to do with it.
सेल करेंगे तो GST लगी जाएगा और GST उधर से चार्ज करेंगे, उधर दूसरे को पे.
Sir, at that time, sir, charge करके हमने नहीं पे करा. In that case, then GST question will come. Lying it in the custom, no GST question can come. In my mind. How GST can come when you have made the purchases only? GST comes into picture only when you make the sale. Sale का इससे कुछ मतलब है या नहीं है? I don't understand.
सेल का नहीं है सर, ऐसा है कि इसमें इंपोर्ट हुआ है बाहर से गुड्स.
हाँ जी.
The goods are lying in the custom bonded warehouse.
बिल्कुल सही बात है.
Before commencement of the CIRP. Now the company is under liquidation. If I am filing, I am claiming the goods from the custom department that by considering the judgment of the Supreme Court, you have to relieve my goods. At that time, if the custom department is agreed, suppose custom department is agreed to relieve the goods without receiving any payment of the custom duty, and they have to file the claim as per the judgment. But my question is that because the GST is also to be payable, if the goods are relieved,
योगेंद्र, यही तो मनोज जी कह रहे हैं कि GST is not applicable at that stage.
सर, इंपोर्ट पे IGST applicable है.
Okay, राजेश जी, देखो, I am not a GST expert, so I am not restraining myself.
सर, अगर इंपोर्ट पे IGST applicable है, बिल्कुल ठीक कह रहे हैं आप. I remember कि वो क्लाइंट्स उनका हाथ है, जो उनको इनपुट क्रेडिट मिल जाता है. सर, हाँ जी, क्रेडिट मिल जाता है, उनका मिल जाता है. हाँ जी. तो सर, इसको भी अगर ये देखिए, इसको भी आप कस्टम की तरह ही ट्रीट करोगे. इसकी आप सेपरेट ट्रीटमेंट नहीं दोगे आप.
कस्टम की तरह ही ट्रीट करना होगा ना. We have to not to make the payment of IGST.
हाँ जी.
At the time of relief of the goods.
हाँ जी.
इस बारे में कुछ क्लैरिटी नहीं है. आप मदान साहब कोई केस की जजमेंट दे सके तो बेशक, अदरवाइज इसके बारे में कोई क्लैरिटी नहीं है. कस्टम और IGST के बारे में मुझे तो नहीं है, लेकिन दिस इज IGST एप्लीकेबल ऑन द इंपोर्ट ओनली.
राजेश जी, आप मुझे क्वेरी बना के भेजिए, मैं उसका रिप्लाई देता हूँ.
ठीक है सर, मैं भेजता हूँ.
ठीक है. थैंक यू.
I think it's time now.
Yes, sir. Thank you, sir, for engaging in such an extensive discussion on various recent judgments passed in the realm of IBC. I'm sure all of us have gained sufficient insights on various issues plaguing the court for almost 6 years now. And we hope to have you in further discussions also, because it is always a pleasure to learn from your vast and enriching experience. Now I invite Mamta ma'am to conclude the seminar with a vote of thanks.
Mamta ji, before Udita ji, I would like to share one thing. मदान सर ने 2-3 बातें कही, तो एक instead of sharing all this in the beginning, मैं 1-2 बातें अपने आईपी ब्रदर्स के लिए शेयर करना चाहूंगा. एक तो सब लोग ध्यान रखना, 25/12 लास्ट डेट है IBBI की इम्पैनलमेंट की. तो इन द सेंस कि अगर किसी ने अप्लाई करा या नहीं करा एंड ही वांट टू बी इम्पैनल्ड देयर, तो ही मस्ट टेक केयर. एक ये था. दूसरा एक मैंने
इसी पे मनोज जी, इसी पे मेरी अनसॉलिसिटेड एडवाइस है, डोंट गेट योरसेल्फ एम्पैनल्ड.
सर देखिए, इसी करके हम आपको बुलाते हैं कि आप हमारे को हमेशा एक ऐसी एडिशन देते हैं कि जो एक रूटीन से हटके होती है, और वी लव टू हियर फ्रॉम यू. सर इसकी थोड़ी सी लॉजिक भी बता दो ना हमारे को.
लॉजिक बहुत समय लग जाएगा लॉजिक बताते हुए.
नहीं सर, आप ब्रीफली बता दो.
सर बड़ा सिंपली बात है, एम्पैनलमेंट का मतलब है गिविंग योर कंसेंट.
एग्जैक्टली.
क्या आप कोई भी क्लाइंट ऐसा पकड़ते हैं विदाउट डूइंग द ड्यू डिलिजेंस ऑफ द क्लाइंट? Whether anybody who walks into your office, you entertain him as your client without settling anything? Here you are settling for a transaction, for an assignment, जिसमें आपका कोई ड्यू डिलिजेंस नहीं है, ना एप्लीकेंट का, ना कॉर्पोरेट डेटर का. You are not sure whether you are going to get a single penny or not, but you are responsible and liable for all compliances.
सर आईपीएस के बिहाफ पे मैं आपको इसका ये आंसर दूंगा.
हमारे यहाँ क्या फायदा है?
4,500 आईपीएस हैं, उनसे बेचारे 1000 आईपीएस तो अच्छा काम कर रहे हैं विद द ग्रेस ऑफ गॉड. जो आईपीएस यहाँ पे हैं, दे आर ऑल डूइंग गुड वर्क. लेकिन 3-3,500 करीब ऐसे आईपीएस हैं जिनको अभी तक एक असाइनमेंट नहीं मिली, एंड दे आर डाइंग टू गेट वन असाइनमेंट.
अगर ऐसे किसी को अगर एक्सपीरियंस लेना ना, फ्री में एक्सपीरियंस लेना, प्लीज मेरे पास आ जाइए, मैं बहुत सारा एक्सपीरियंस दिलवा दूंगा.
चलिए ठीक है,
विदाउट एनी रिस्पॉन्सिबिलिटी एंड लायबिलिटी.
बहुत अच्छी बात है, बहुत अच्छी बात है.
नो कंप्लायंसेस, नो फॉर्म्स टू बी फाइल्ड प्लीज.
बहुत अच्छी बात है सर. एडवोकेट तो करते ही ऐसे हैं, यानी कि ये हर चीज के अंदर हर बंदे को बचाते हैं, हर किसी को करते हैं विदाउट एनी रिस्पॉन्सिबिलिटी. सर वो तो हम आईपीज ही हैं जो हर जगह आंसरेबल है, चाहे वो एनसीएलटी है, या आईबीबीआई है, या कोई एनीथिंग एल्स है. यू कैन अंडरस्टैंड पेन्स. आपने हमारे हम जब
मनोज जी, मैं कुछ और करूं, मैं कह रहा हूं अगर एक्सपीरियंस लेना ही है,
ठीक है सर, ठीक
है. एक दी एक्सपीरियंस लो जहां पे रेम्यूनरेटिव एक्सपीरियंस. इफ यू आर नॉट श्योर अबाउट द रेम्यूनरेशन, and liabilities are certain, but remuneration is not certain. So why to invite such a trouble for yourself? आप बाकी लीजिए ना, एप्लीकेशन के टाइम पे लीजिए ना, आप कंसेंट दीजिए, सेटल योर टर्म्स, टेक मनी इन एडवांस, गिव योर नेम एंड IBC-IP, IRP, RP, liquidator, whatever you want. Why through the panel? This is where the liquidators are being appointed from the panel. मुश्किल से 5 लाख रुपए की एसेट्स नहीं है अंदर. आप सोचिए जरा क्या मिलेगा आपको, और मिल जाएगा उसमें सीआरपी कॉस्ट ऑलरेडी आउटस्टैंडिंग खड़ी हुई है. व्हाट आर यू गोइंग टू गेट आउट ऑफ दैट?
बिल्कुल ठीक.
सॉरी, मतलब बोल्ड स्टेटमेंट देता हूं
नहीं सर, आप बोल्ड स्टेटमेंट देते, हम लोगों को एनलाइटन करते हो, और एनलाइटन भी आप बिल्कुल प्रैक्टिकल एस्पेक्ट से करते हो, एंड दैट इज व्हाई वी लव टू हियर यू अगेन एंड अगेन. तो चलिए, आईपीएस कैन टेक देयर एडवाइस एंड okay, Mamta ji, if you permit me, and Udita you also, actually एक मैंने छोटी सी presentation बनाई थी on the basis, because we have lot of the understanding, or maybe you call it as a misunderstanding, कि OC के ऊपर जो interest है उसको हम section 4 के लिए या claim admit करने के लिए कैसे use करेंगे. If you want, I can take it right now, or we can take it in the next meeting also, because it's already 5.
So we are all dil mange more.
Yeah. Okay. I'm just sharing that particular PPT with you.
Mr. Madan, would you be available, or should we do the honors for you, as you say?
I'm always with you.
Thank you. Thanks so much.
और मैं अभी बता रहा हूं, बिफोर हैंड बता रहा हूं, जो भी मैं इसको डिस्कस करूंगा मदान सर उसके अंदर डेफिनेटली विल ऐड समथिंग, will definitely add something and enlighten us with that. Okay. I think my PPT is visible now.
Yes, yes.
This is a brief introduction. I'm just, skipping it off. Okay. Yeah, my contentious issue is, which I've been discussing with everybody, is that whether operation debt includes interest in it or not. Before we delve into it, let's understand the law which is there. Section 521 defines it. Section sir ने भी एक केस डिस्कस करता, उसको मैं भी थोड़ा सा लूंगा. Section 521 defines an operational debt as a claim in respect of goods or services, including employment, or debt in respect of payment of dues. अब डेट क्या है? डेट की डेफिनेशन हमारी सेक्शन, ये मैं इस करके अभी पढ़ रहा हूं बिकॉज दिस विल बी यूज्ड इन द रिलेवेंट एनसीएलटी और सुप्रीम कोर्ट जजमेंट्स. सेक्शन 311 डिफाइंस डेट as a liability or obligation that is due from one person to another and may include financial and operational debt. ये सेक्शन 58 को financial debt ने डिफाइन करा है, तो इसको मैं स्किप कर देता हूं. अब इसके अंदर लॉ क्या सेटल हुआ है? Let's understand that law. इसके अंदर सबसे पहले सुप्रीम कोर्ट ने जजमेंट दी थी पायनर के केस में, whereby they said that in case of operational debt there is no consideration for time value of money, hence interest will never be included therein. Because this thing, we as an IP practice, we require it at two places. One is, when we are filing application, we have to see the section 4 amount, जो पहले 1 लाख था बाद में 1 करोड़ पे होगा, कि whether in that case 1 करोड़ के अंदर that principal plus interest will be included or not, only interest will be or only principal will be included. तो पायनियर का केस में ऑनरेबल सुप्रीम कोर्ट ने कहा कि सिंस सीइंग द डेफिनेशन जो हमने पहले पढ़ी थी 521 की, कि उसके अकॉर्डिंगली टाइम वैल्यू ऑफ मनी नहीं है, तो ऑपरेशनल डेट के अंदर इंटरेस्ट विल नॉट बी इंक्लूडेड. बट उसके बाद ये एनसीएलटी ने ऑब्जर्व करा इन दीज टू जजमेंट, इन विटसन के केस में और एक ये वेम्बरी के केस में, कि जहां पे अपरेंटली कोई एग्रीमेंट नहीं है, मीनिंग देयर बाय दैट इफ यू डोंट राइट एनीथिंग इन द बिल और इफ यू डोंट राइट एनीथिंग इन द परचेज ऑर्डर, दैट इन केस ऑफ डिफॉल्ट और in case that you are given such the 15, 30 or 40 days of credit, and if you don't make the payment after that, we shall charge you say 12, 18 or whatever amount of interest from you. In that case, it is not, this operational debt will not include the interest element. It is, in consonance with Pioneer judgment. But, NCLAT has revolved the law. In DF forfeit case, NCLAT held that it can't be expected that delay in payment is left uncharged, and hence an operational creditor claiming interest is justified. यानी कि इस जजमेंट को उन्होंने इस पर्टिकुलर जजमेंट के अंदर इस चीज को रिवर्स कर दिया. और उसके बाद ये 2 जजमेंट मैंने ढूंढी है. इन केस ऑफ सीआरबी साउथ वर्सेस held that excluding interest from the overall claim in cases of operational debt was an erroneous approach and overruled the judgment of NCLAT for admission under section 9. Similarly, also held Prashant Agrawal versus Vikas. कहने का मतलब ये है कि इन 2 केसेस के अंदर जो लेटर आई हैं, ये 2022 की जजमेंट्स हैं, इनके अंदर एनसीएलटी ने कहा कि आपको इस जो इंटरेस्ट एलिमेंट है ओसी के अंदर वो आपको लेना पड़ेगा फॉर फॉर एडमिटिंग द क्लेम बाय द आईपी. Again, this is an old judgment कि interest आपको नहीं लेना पड़ेगा. In this case, they have held, NCLT has held in this particular case. I don't need to repeat it again. Okay, no. I leave my desk open to the everybody. How should we, go for it? What is the conclusion against it? Madan sir, Mamta ji, please share your views.
So Madan ji first, please.
मनोज जी, मेरा मानना ये है कि सुप्रीम कोर्ट ने अपने किसी भी जजमेंट को ओवरटर्न या ओवररूल नहीं किया है. सुप्रीम कोर्ट ने सिर्फ क्लैरिटी प्रोवाइड की है that for the purposes of filing of an application under section 9, what can be included, what cannot be included. If there is undisputed amount of interest which has been calculated as per the available documents or as per the contractual terms, that shall be added to the amount of the operational debt. And if the aggregate of the both is more than 1 CR, the application under section 9 can be preferred. This is what the only interpretation as per me, nothing more. However, the last आपने दिखाया है, last में जो मैंने जो पढ़ा है आपकी slide से, that simply on the basis of the interest on the operational debt, an application under section 9 cannot be filed. It has to be aggregate of the two, that's all. Or in sync with each other. No overruling, no overturning.
This is very important because जब हम IP claim admit करते हैं OC का, तो हमेशा ये question arise होता है कि अब उसका interest element भी claim में admit करे या ना करे. तो सर ने इसको clarify कर दिया and Mamta is also agreeing with it. Any contrary view against that?
Not in this, but for a sake of better understanding, there's a matter which has been a judgment given by NCLAT Delhi on the 20th of December, that is this month, of Balaji Paper Pack Private Limited, which I was going through. I think for the purposes of OC understanding claims, it's very important. There, the new aspect has come that the dispute, it was about dispute, and it said that the dispute must be specific with regard to the same amount. I repeat, the dispute must be specific with regard to the same amount. This is a very new thing that has come up because previously we knew that, you distinguish the chaff from the grain, and if there is a slightest amount of dispute, then NCLT, because of summary proceedings, will not get into it, etc., etc. But now it has been said that it has to be on the same amount. Previously, we used to think even there's a slightest element of dispute, and then you don't need to separate. It can be just classified as a disputed stuff. So this particular judgment, I think my friends may like to read it in details. It may be very important.
So if I may quantify, Mamta, this judgment, please. Suppose there is an outstanding amount of operational debt of 5 crores of rupees. And out of 5 crores, the dispute is with respect to 2 crores of rupees only.
Absolutely.
Still, this application can be admitted.
Correct. So this is quite important. You may like to see this.
Right. Thank you.
Thank you, Manoj, and then I think we can take it to closure. Traditionally,
you always close our meeting. I request you to, have the words for closing of the meeting.
Thank you. So it's an arduous task it's an arduous plus it's a heartening task both to really give a vote of thanks to Mr. Madan, a person whose demeanor is definitely so well known to us, a person who is not only famous by his name, but also by his deeds, by the way he helps and he comes for everybody and he takes stand for all of us. So thank you, Mr. Madan, for sparing your beautiful Saturday evening and that to pre-Christmas, when the entire family is always trying to get into our time zone. In spite of that, you've given us this time. Thank you to all my esteemed participants who have made it sure to come here, because IPA is a platform along with the other associations which makes sure that our well-being is very important. And Mr. Manoj Anand would be really thanked quite a number of times because he plays the shots from the front and he makes sure that he's taking everybody along while he takes larger strides towards making IPA more meaningful in its existence. So thank you, Manojji. Thank you, Udita. It was, kudos to you that at this age, you're doing so well. Aapke age mein hum log, we were never thinking about our career so much, but it's very heartening to see people like you and so career driven. I only have one advice through you to everybody, that let us all, especially the girls, and I'm not being feministic or something like that. I just want to say that we all should well balance our lives. It's important to be very career oriented, but it's also important to weigh your other side of the life equally well. Udita, we also wish you all the very best. And all the female colleagues who are here, wish you all the very best. You can be the best of the IPs, but never forget that you are the best mother and a wife and a friend. So we need to play our roles very, very well. So thank you very much. Merry Christmas. And let's see what Santa Claus in the form of IBBI has for us in the next years to come.
and wish you everybody Happy New Year also. And we're thankful to Mr. P.T. Joy also. And we shall come up only in the next year. And hence, everybody from IPA side, from Madan sir, from Mamta ji, from Mr. Joy, from Udita, and from everybody who's present there, still 27 participants are there. At peak, we are having around 50. Happy New Year. And to everybody, Happy New Year to everybody. It brings prosperity, everything, more cases, less litigation to IPs, definitely more to advocates, but less litigation to the IPs. Happy New Year, and do keep joining us and encouraging us to have such webinars in the year to come also. Happy New Year to everybody.
Thank you very much. Thank you so much.
Thank you.
Merry Christmas, Happy New Year. Thank you.
Happy New Year.